Yes, sir. I filed a bail application CRL number 387/2019. So I was mentioned last Thursday.
Criminal appeal.
Yes, madam. Criminal appeal.
Please give it.
Terminal benefit of senior citizen. Terminal benefit of senior citizen.
So now, 24 लिखेंगे ना
Quickly list item number 1.
Your Lordship, in item number 1, I'm appearing for the caveat petitioner, Your Lordship. On the previous occasions, Your Lordship, a direction was given to the petitioners to file an additional affidavit showing if there is any rule showing that no deputation fees can be given to the employee, Your Lordship. Thereafter, they filed an additional affidavit. Your Lordship, I filed a reply to the additional affidavit, Your Lordship. Of the copy.
That reply is not on record.
No, Your Lordship, I filed it yesterday.
When you filed that?
I filed it yesterday. Today morning, Your Lordship, I filed.
You have received the copy. Salabala General and Counsel appearing for the cabinet submitted that after receiving the copy of the additional affidavit, she has filed reply the same today. Stop. Let the reply be placed on record. Reply filed by the cabinet will be placed on record. Can it be taken up day after tomorrow?
Oh, pleasure.
This matter on 20th of August 2025. Mr. Deepak Buchai, Plans and Development Council is present. Yes.
Pleasure.
Item 2.
Mr. Pujari is out of session, so I was not answering. Pujari is out of session, so I was not answering.
Mentions on behalf of Mr. Vasudev Pujari for adjournment on his personal problems. In Mr. Pujari is supposed to return next week. Please this month. At a full convention from 1st September 2020.
Item 3.
Item 3, Millet, I'm appearing for the opposite party bank. In pursuant to your Lordship's letter, they have filed an affidavit, they have served it on me. Which I pray that I'll file a reply to the same message.
I'm sorry for this.
There was a bereavement in my family, so I couldn't obtain the instruction. I'll file a reply affidavit.
Who has filed the
The petitioner has filed an affidavit pursuant to your
You
Lordship.
are for the bank.
I'm for the bank.
You want to obtain instruction.
Instruction and file an affidavit.
Land counsel for the bank opposite party submits that he has received the affidavit filed by the land counsel for the petitioner, and he may be given some time to obtain instruction on such affidavit and file the reply if necessary. So it can be taken off for a week after.
Millet.
What do you say?
No.
Out of this matter, in the week 1st September 2025.
Millet.
Item 4.
Yeah.
Island 16 application under surface similar first.
Working surface application, application. 14.
1062/25, the double. The similar order passed.
Don't see the each and.
106. Okay, now.
Yes, number change.
No more could be.
Next.
Item 5.
The opposite party bank matter. After that, lordship had directed the petitioner to submit an affidavit, file an affidavit stating that how much he will deposit. He has not filed.
No, I would issue it.
No, my lord, not. It is also not filed because nothing has been indicated in the cause list also.
Pass it over, let us see, this may come. Pass over. May come. This is.
Item 6.
Please, Your Lordship. This is a matter which arises out of the Insolvency Bankruptcy Code. Your Lordship, see page B of the synopsis.
Yes.
Now kindly see, Mills, paragraph 3. Lord, this company went into CIRP on 22nd of March 2022. And my lords, paragraph 4, a resolution plan was filed and the same was approved on 26/9/2023. Your Lordships have it?
Synopsis. B.
Synopsis,
Page B.
page B.
Yeah.
My lord, this is how I. So paragraph 3 says on 22nd of March 2022, this company went into a CIRP proceedings, that is Corporate Insolvency Resolution Process. And my lords, a resolution plan was submitted on 4th of November 2022, that is paragraph 4. And the NCLT approved it on 26/9/2023.
And who is the resolution applicant?
The resolution applicant is the present petitioner who has kept it.
Okay.
The issue is this: there was some dues prior to this date, that is prior to 26/9/2023. There was some dues of 4.5 crores to the water department. They did not go there. And your lordships have said once the resolution plan is approved, everything prior to that get extinguished. I have paid it under protest. Now the only question is, my lord, I seek refund. Let my learned friends file a counter, and then your lordship can decide this. In fact, it is covered by judgments of your lordship's court also. There is one judgment of Ekor, where following Mishra, your lordships have held that because of section.
That was covered under the.
That was a prior period. So what your lordship says that all debts prior to 26/9/2023, being the date on which the plan was approved, they all get extinguished by virtue of section 30.
Yes.
Let us see the decision. Your lordship may have a look at this decision. Yes. Let me give your lordship the first judgment of the Supreme Court on this point. My lords may kindly first see page 700. Read the reason. Page 700. This is 2021 9 SCC.
Yes.
My lord, section 31 of the IBC code, my lords, it was amended. And the amendment came on 16th of August 2019. Kindly see page 700. Here. Para 73, my lords. White section 7 of Act of 26 of 2019, SR number 29 so dated 16/8/2019, with effect from 16/8/2019, the following were added into section 31 of the IB code. What's have it, my lords? Including central government. So the question was whether state government, central government dues get extinguished or not. Including central government, state government, or any local authority to whom a debt in respect of the payment of dues arising under any law for the time being in force, such authorities to whom statutory dues are owed. So this was added. Now, if my lords kindly turns to the finding of the Honorable Supreme Court, the conclusions are at page 716.
Para?
My lordships, kindly see my lords, conclusion para 102. My lord Justice Sahoo has 102.
In the result.
In the result, we answer the questions framed by us as under. We are concerned with the first question. That once a resolution plan is approved by the adjudicating authority, under subsection 1 of section 31, claims as provided in the resolution plan shall stand frozen and will be binding on the corporate debtor and its employees, members, creditors, including central government or any state government or any local authority, guarantors and other stakeholders on the date of approval of the resolution plan by the adjudicating authority. All such claims which are not a part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceeding in respect to which a claim which is not a part of the resolution.
What was the claim you, according to you?
Lord, what they say was that you pay 4.53 crores, which was, according to them, payable by the erstwhile. My lords may kindly see annexure 4 at page 184. My lords have it. Annexure 4, 184.
Yes.
Now kindly see, my lord, this is 4.5573, etc. And I made a representation to them at page.
That this demand is 21/6/23.
Yes, yes. This is for a prior period.
Yes.
This is for a prior period. And I file a representation. 198, if your lordships kindly see.
Yes. 190. Challenging the answer. Challenging the answer.
Kindly see, my lords, page 204, annexure 10. This is 7th of April 2025.
What it says.
My lord, what I say is, because of the judgment, I lordship show you, kindly come to page 205 minutes. Paragraph D. Your lordships have it, my lords. Page 205.
In this regard.
In this regard, it is also pertinent to point out that the Honorable Supreme Court in the case of so and so, your lordship read that paragraph just now. Thereafter, in view of the clear statutory mandate under 3.1, as well as the law declared by the Honorable Supreme Court, since the approved resolution plan has already provided for full and final settlement dues to the operational creditor, which have been already paid, all other claims as mentioned in the above letter stand extinguished, and therefore is now other subsisting claim against the company. In view of the foregoing, we once again request you to kindly extinguish all outstanding demands, as the demand as per the provisions of the approved plan under section 31 of the IBC, etc., etc. But still insist. And finally, what I do is, I make payment. And your lordships will see page 221, if my lords are kindly pleased to see me. I deposit the entire amount, annexure 18 221. If my lords will kindly see, my lords, subject. My lords have it. Annexure 18.
Under protest.
Under protest. So now what I seek is, I seek refund of that money, because that was not billed by me.
What NCLT says.
No, NCLT I don't have to go back, because NCLT proceeding is over. They did not go to the NCLT and lodge a claim. And the law is...
You can very well move an application there in NCLT.
No. This court only has decided several cases. I'll give you lordships one more judgment. This is Pekor. Division bench of your lordships court.
Where is it?
Kindly see paragraph 24.
24 of both.
This paragraph 24 of this judgment, fake out. This is a division bench of your lordship's court. Because once the plan, NCLT is no more there. They are functor sufficient. Kindly see at 24 minutes at page 8. My lords have it.
Yes.
Section 31C, 31(1) of the IBC makes it further clear that once the corporate debtor and its employees, members, creditors, including central government, state government, to whom debt in respect of any payment arising from any law for the time being in force, such authorities to whom statutory dues are owed, guarantors and other stakeholders involved in the resolution plan. Indeed, OP number 2 is an officer of the state government, is equally bound by the ARP. He is precluded from raising any demand for a period prior to the plan effective date. Now, plan effective date, your lordship saw at page B of the synopsis to be 26/9/2023. So that is the cutoff date.
Yeah.
Indeed, the OP number 2 is so and so. He is precluded from raising a period prior to the effective date. The legal position in this regard is well settled in so and so, wherein held at 31 of the IBC, once the COC approves the resolution plan, it binds all stakeholders as it is observed as under. Section 31 of the code makes it clear, once a resolution plan is approved by the committee of creditors, it shall be binding on all stakeholders, including guarantors. This is for the reason that this provision ensures that the resolution applicant, now this is important, starts running the business of the corporate debtor on a fresh slate. As they are saying, you are taking over the company. Everything prior to the cutoff date goes, and you start seeing this, fellows. Ultimately, your lordships kindly come to paragraph 34 and see the directions.
Yes.
34 minutes. My lord,
Demand notice that.
yes, they quashed it and they direct reform.
Same demand notice you are
Same,
telling.
exactly, sir. I'm grateful. So let my learned friends file a reply. If they say it is after the cutoff date, then that's another story.
This petition has been filed by the
Back there is challenging the annexure 13, that is the dated 17/5/25, that they are page 214.
yes. Is now they have deposited this.
Have deposited.
Question is that
Because they insisted.
entitled to get refund of that amount.
Under protest, they have deposited and seeking.
of that. The petitioners filed with petition. Passing the demand notice dated 17/2/2025 and 17/5/2025 by the superintendent engineer, main dam division, Urla. That's the opposite party number 3. For an amount of rupees 4,55,73,853. Also, the decision of the state government in imposing the payment based and such notice as a precondition for execution of the water agreement, which is contrary to the provisions of insolvency and bankruptcy code of 2016. With the order prayer for a direction to the opposite parties to perform the payment of rupees so and so made by the petitioner number 1 for the protest in addition to the intended demand, along with interest of the rate of 18% per annum till the date of the regulations. Mr. Ashok Purja, branch senior advocate, appearing for the petitioners, along with facing reliance in the case of Mishra and Sons Private Limited, to the authorized signatory versus sponsor, reported in sponsor. The petition of this Wireless Corporation Limited versus State of Orissa and others reported in 2020 SEC Online Orissa 347 submits that in view of the ratio down and the approach to the decision, the demand was raised by the demand notice dated 17/2/2025 and 17/5/2025 are not sustainable in the eyes of law. And since the petitioner has made payment of such an amount and is entitled to get a refund of the same. The Grand Council submits that all liabilities of the petitioner number 1 prior to the implementation date under the approved resolution plan, that is 26/9/2020, stands completely extinguished by law in terms of the approved resolution plan, which is also binding on the opposite party, and therefore there is no basis for raising the improved demands and same to be set aside on its own. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. From counsel for the state accepts notice on behalf of all the opposite parties. Extra copies of the petition will serve on the Land Council for the state. Matter be placed after 4 weeks. Counter affidavit if any is filed in the meantime.
Why corporate debtor is not a necessary party here?
Because I have stepped into the shoes of the.
But they are also entitled to be heard.
I am
Tomorrow some problem.
I am the corporate debtor now.
But
Because I
that's
have
right,
taken-
but the original debtor has to be there, otherwise something he may.
No, because only way this is if they say.
Why can't you make them a party? The
I am the-
original debtor.
There is no more there because I have stepped into.
You
issues.
stepped into, but we don't know. He may say something. A formal party, maybe he is also.
Let me check.
He is a party to the NCLT proceeding.
Actually, the NCLT proceeding was started by State Bank of India
Yes.
because the reuse were not covered.
Yes.
And he could not participate because he, under the law, my lords, if I am taking over X's company, then X is not a party. So what happens is after
But
the,
whoever were the parties before the NCLT, they
Yes.
are necessary to be.
the State Bank, etc. But what your lordship may read those two judgments. In Fakor, your lordships have held, Ghanshyam Mishra, what your lordship held over, Supreme Court here, that the date of cutoff date is 26/9. Anything prior to that get a result of 31/8.
You are right. There we are agreeing.
I will examine this, and if necessary, my lord, we'll make that.
Tomorrow something.
I will examine. Because now, my lord, the due sought to be recovered is that of the state government.
But they may be a pro forma party, but they should be there.
I'll examine.
Examine it.
Yes.
The question is posed to Reliance in as to why the State Bank of India so and so have not been included as party, though they were the parties.
At the instance of SBI, it was started.
Yes.
The lordship may say, at the instance of SBI, the proceedings before.
Instance of the SBI. Examine.
Yes.
Whether they are
Party or
Item 5, our petitioner has come.
He is going to be settled my loan because I negotiated the branch and matter the bank loan my loan.
ready to deposit.
I negotiated the and it is going to be settled my loan.
We took time on the other day when the matter was listed, 6 to file an affidavit. How much amount you are ready to deposit as an upfront amount so that the matters can be referred to peaceful mediation. Right. So you have not filed the affidavit.
Now, my as a branch manager, my And the matter is going to be settled, my lord, in negotiation.
You withdraw it.
Withdraw it and settle it.
You can settle it there, you withdraw it, there is no problem. Insisting, since you made a statement, we recorded it and accordingly adjourned the matter. But if you say that at the bank level, you can sort out the problem, then there is no purpose in keeping this petition pending here.
We'll record your statement and dispose it up.
Okay, the land council for the petitioner submit that the petitioner has some talk with the bank authorities and the matter is likely to be settled and therefore he is not interested to proceed with the petition. In view of session, the said petition is disposed of as not proceeded. Mr. Anjan Kumar Vishwal and counsel for the Punjab National Bank is present here.
Item 7.
I may be permitted to move this submission. Lord, in this case, the admitted fact was that there was a proceeding before the DRT for realization of the dues. The admitted fact is that a decree was passed. Admitted fact is it was issued. Admitted fact is a warrant has been issued against me. Your Lordship must be asking me a question that then why you have approached this, why you have not gone to the tribunal. The answer is this, my Lord. I have never signed any loan document. My signature was forced. Loan was obtained behind my back. Likewise, DRT proceeding, I was served with any notice, but I cannot prove it because everything has been seized by the CBI. Then, my Lord, suddenly I found a warrant is pending against me. That is why I approached your Lordship in this writ application. Your Lordship may kindly turn to pay. The CBI has filed a charge sheet, a proceeding is pending, my Lord. Not against me.
Who is the borrower?
My Lord, borrower is the Mishra. Manoj Kumar Pradhan.
Then according to you, Manoj Kumar Pradhan might have caused it.
Yes, that is there, not in the charge sheet. Not, I want.
But you have not made them parties. You have not even made them parties. Then
Thank you.
against the decree you are saying something against someone. He is not a party before us.
Your Lordship may kindly have a glance. I am making a party. That is not a problem. But that may satisfy your Lordship's conscience first that it is a case for interference. No, otherwise, why? But page 13, your Lordship may kindly see. This is a part of the charge sheet filed by the CBI. Has your Lordship got it? Has your Lordship got it? Page 13. Last paragraph. It is abstract Sri Mahavir Maji in conspiracy with Lakshmingad Patnaik and his wife Anusaya Patnaik sanctioned rupees 10 lakhs as house building loan to the house at Kannur without the approval of the office at Bhubaneswar. The loan was sanctioned without the approval of the house by Kotak Development Authority and without any agreement. The loan amount was wrongfully credited to the loan account of Nalnikanta Patnaik described earlier. This loan has also become an outstanding amount of rupees 11 lakh 79,000. It is also there that Mahavir Maji in connivance with Sri Manoj Kumar Pradhan. Has your Lordship got it? Partner of Messrs. Hotel Manorama Plaza Kotak sanctioned rupees 15 lakhs as a credit loan to Sri Pradhan on 31/8/2001 without any security for the loan. They also fraudulently shown Sri Saraj Kumar Pradhan, who is the brother of the loanee of Manoj Kumar, guarantor and his fixed deposit of rupees 1,65,000 763 used by the bank was guarantee against the said loan. It has been affirmed by GEQD that the Sri Saroj Kumar Pradhan has not signed in the loan document and his signature has been formed.
But Mr. Mohanty,
I am
if
Saroj Kumar Pradhan.
if you come to that annexure 5, which is the warrant,
Yes, sir.
it has been stated that the presiding officer of the tribunal has sent to the recovery officer the certificate
Yes.
under section 1917 of the 1993 Act for the recovery from the certified debtors, right?
Yes, sir.
So there must be an adjudication on the basis of which.
That is what I told.
Carry that order.
That is annexed debt recovery tribunal without order.
What is that?
This one.
My lord, page 29.
25.
Page 29, it is a final order passed by the DRT, my lord, wherein paragraph 16, that was categorically stated that the so-and-so are the jointly and severally liable to pay the dues of the bank with the further interest and costs. So, my lord, my respectable submission before.
This petitioner, Saroj Kumar Pradhan.
Yes, my lord, is the
was
defendant number 4.
Was a party in that.
In the defendant number 4, my lord.
My case is that I have
Defendant number 4.
never received any notice.
Let us take one by one. What Mr. Mohanty says that though it is mentioned that the counsel for the defendant number 4, there is none in the first page of that order, but in fact, no notice has been served.
Then
So
second
how
page
this aspect
expiring.
has been, the paragraph number 3 has been mentioned, Mr. Mohanty, that you remained ex parte. Ex parte obviously presupposes the notice has been served on you or it has been held to be
It
served.
is supposed to be. But the entire thing was behind my back. I only came to know it from the certificate, warrant.
No.
But I could have applied for the.
On which date you were set ex parte?
I don't know. Because the entire record is seized by the CBI. That is my predicament. Otherwise, I would have come out with a order sheet before your lordship.
But you are the brother of the borrower.
Yes, that is admitted. But what has happened? I have not taken the loan. My entire fixed deposit was placed as guarantor forging my signature.
Page 4, if you see the charge sheet, page
Yeah.
24, middle paragraph, page 24, 25.
He is the manager.
Page 20, middle paragraph.
The above act committed by the accused Manoj Kumar Pradhan constituted an offence.
Page 24, middle paragraph,
Okay.
investigation report.
Further, that signature of one Sri Saroj Kumar is available in the guarantee form for the aforesaid loan. Sri Saroj Kumar Pradhan is the brother of the accused. Sri Saroj Kumar Pradhan denied having signed on the said letter of guarantee and disowned his signature is also corroborated by GUQD.
Yes, read. Accused M.K. Pradhan.
With dishonest intention, has produced a fake guarantee form purported to be signed by Sri S.K. Pradhan to obtain the said loan. The loan amount became.
But what can we do if you have an
Well,
alternative remedy available with you?
At least, well, a remedy, what remedy, my lord?
Because you are not appeared and an order has been passed by
That
the
is what
DRT.
the order says, my lord.
But
Order says that it is also, I was also expecting, my lord.
yes, that you are to satisfy us that by producing at least the order sheet,
Well,
that
how-
you have been wrongly
It's
shown that it has been.
Government, my lord, everything is with the CBI. The entire DRT document.
No,
has
this
been-
order sheet, what the CBI will do with this order sheet? Yes.
Entire file they have taken, ma'am.
Where have
No,
you said
no,
that
no.
entire file they
Huh?
take?
Let us see that where you have taken that this DRT record has been seized by the
Why the
Invest-
judicial
That
record?
ground has not been taken.
then
How the judicial record will be taken by the
My
CBI?
lord, before issuance
You
of
have to move an application for
Warrant of
setting
arrest,
aside
the recovery
order.
20ରୁ 25ଟା ପର୍ଯ୍ୟନ୍ତ order ପାଇଲୁ
Hmm.
ଆଉ ତା ଆଗରୁ ପାଇଲୁନି
we are concerned with that particular order sheet that is set ex.
Lord, this present warrant of arrest has been issued. Before that, the recovery officer has sent a show cause of warrant of arrest and the order.
Fraud vitiates everything. He is saying the fraud and it has been investigated. CBI has filed a charge sheet saying there is a fraud. If fraud is there, everything we see it.
All those things.
Miller, decree has already been passed, Miller, of the year 2007.
Said I would have known that I could have.
The decree has been passed. On the basis of the decree, recovery proceeding has been initiated.
I don't say that there is.
Miller, he is not responding.
Maybe Mr. Mahathi, you just find.
Your Lordship, kindly see what is the language of the recovery officer.
What is it?
Quote the decision. Every case depends upon the factual scenario. Don't
My
know
lord.
the decision. We are asking you, Mr. Mahanti, that if you say that the particular order on which date you are set ex parte,
That is 2007, my lord. I applied for the certified copy of the order sheet. I got it from 2020 to 2025. Prior to that, my lord, I didn't get it.
please may just give it in writing with a memo. At least we have to see that whether that order sheet is available with the DRT or not. So that
Let him.
because you say that you have been prevented once you came before the
Let
DRT.
it come tomorrow, my lord. Let him file an affidavit. Why should I take
Who is the complainant in the FIR?
Saroj Pradhan is cut off, no?
No, you are not the complainant. The bank is the complainant.
Bank is the company.
The writ petition has been filed by Saroj Kumar Pradhan challenging inter alia
And you see what to do.
the warrant of arrest issued on 24/7/2025 by the recovery official under section 25 of the RBDBFI Act 1993 to the inspector in charge of police Madhupatna police station. And it shows that the presiding officer, Dev's Recovery Tribunal Cutter, has sent to the recovery officer certificate under section 19(7) of the 1993 Act for Recovery from the certified debtors. And the said sum has not been paid by the certificate holder.
Certificate debtor, my lord.
Certificate.
Our local petitioner. Both,
And the warrant is to be executed against both two persons, that is Manoj Kumar Pradhan, as well as the petitioner, who are two brothers, being son of late Purnachandra Pradhan.
as guarantor, my lord.
The Mr. Mahanti and senior advocate appearing for place the order on the basis of which the warrant of arrest has been issued, which is annexed to the petition as Annexure 3. And it shows that the petitioner was defendant number 4 in OA number 1 of 2007 before the presiding officer Debt Recovery Tribunal Cutter, before the Debt Recovery Tribunal Cutter. And in paragraph number 3 of the order, it has been mentioned that he remained expired. The Land Council submits that no such notice the petitioner has
As
received.
instructed, my lord.
As instructed. As per instruction, the petitioner has not received any notice from the Debt Recovery Tribunal Cutter in connection with OA number 1 of 2007. And therefore, the order that was passed, that the order passing him as ex parte is not sustainable in the eye of law. When we wanted to see the particular order in which the was set ex parte, Mr. Mahanti submits that he applied for the certified copy of the entire order sheet, but only few order sheet has been supplied to him. But the particular order on the basis of which the petitioner was set ex parte has not been supplied to him. However, no ground has been taken in the writ petition to that effect. Mr. Mahanti submits that the matter may be taken up day after tomorrow, so that he will file a specific
Affidavit, my lord, by the petition.
however, submits that in connection that the signatures of the petitioner in the bank documents are forged document, and in that connection, a first information report was lost from the branch manager of Central Bank of India, Mahatab Road branch
On 29/3,
on
2007.
29/3/2007, on the basis of which the case was instituted, and ultimately in this case, the charge sheet has been submitted against the brother of the petitioner, Manoj Kumar Pradhan, and others on the 36/2008, and in the relevant part of the charge sheet, it is indicated that the investigation further revealed that the signature of the petitioner is available in the guarantee form for the loans, and the petitioner is the brother of the accused, and the petitioner denied his signature on the letter of guarantee and disowned his signature, which is corroborated by GE. And it is further mentioned that the accused M.K. Pradhan, bracket Lexantu, brother of the petitioner, with dishonest the fake guarantee form purported to be signed by the petitioner to obtain the said loan. Stop. Put up this matter on 20th of August 2025.
My lord, I will file a detailed affidavit, my lord. Because so many opportunities have been given.
File party number one. The affidavit is to be filed, not the, by the.
You would also explain, if you have initiated the FIR,
My lord.
have you brought it to the notice of DRT?
My lord,
You can't say there is a fraud. And at the same
Because the
time, considering
application-
that fact, you get a degree.
but however, the complete.
No, you have to answer that.
No, definitely I will answer it. The reason being, my lord,
In the DRT
The-
order,
the-
nothing is reflecting. Whether you have, it is on your instance, an FIR was registered, investigation was taken place. You should have brought to the notice of.
yes, yes, I will satisfy my lord.
Mr. Mahadik further said that even though it was the duty cast on behalf on the bank to bring it to the notice of the DRT that such a proceeding, such a FIR was initiated at the instance of the bank, and in which charge sheet has been submitted, and in the charge sheet there are observation exonerating the petitioner and rather indicating that the brother of the petitioner has forged the signature of the petitioner, but the same has not been done by the bank with oblique motive which resulted in the issuance of the warrant of arrest against the petitioner. Yes.
May I pray that the warrant of arrest might be kept
In-
in abeyance?
no,
Just
No, 25% to be deposited where the amendment,
Can't move the.
there is a particular, for evidence that they are coming here.
matter is to be listed day after tomorrow, Mr. Mahathir. Yes.
Oblige me, lord.
Item 8.
I'll request my lord to see the last order before I take your lordship to the any other aspect. Order dated 6th of August 2025. Lordship would kindly see. Then I'll take your lordship what the bank has done. The matter is taken up through hybrid arrangement. Mr. Mishra and head counsel appearing for the bank filed some documents relating to outstanding. A copy of the same has been served on Mr. Atul and so and so, appearing the petitioner who seeks some time to obtain instruction in the matter. Pointed out that on 5/7/25, petitioner has submitted a proposal for closing the loan account, and he has having 6 loan accounts. He further submits that on the basis of such application, a letter has been issued by the bank on 31 July 25, wherein no account number has been mentioned. However, it is mentioned that so far as OTS of our amount 2.70 crore for full and final settlement of the bank dues is concerned, the petitioner was instructed to improve OTS offer amount and was also asked to deposit 50% of OTS offer amount as upfront amount of the OTS offer. When we put a pertinent question as to whether the OTS offer amount 2.70 crore, which is mentioned in the letter under Annexure 10, is for all the loan accounts, learned counsel for the bank submits that he wants to obtain instruction in that respect. Mr. Raj so submits that he will file an affidavit by the petitioner that in persons of letter under Annexure 10, 31 July 25, how much the petitioner is ready and willing to deposit at the moment as an upfront amount. A copy of the affidavit be served on the learned counsel for the bank in advance. Bank filed some documents in court today that physical possession of the property has been taken over. Documents are taken on record. Mr. Raj so for the petitioner shall file affidavit on or before 11th of August 25 so that the matter can be referred to special mediation drive mediation for the nation, list the matter on 13th of August. Number one, we have filed an affidavit. In that affidavit,
I think an objection on behalf of the bank to that affidavit.
Just affidavit filed by the petitioner, okay? देखिए objection copy पाइए देखिए जो यदि पहर दिन नबा अपन यदि अधिकार
ମୁଁ ୟାକୁ ଦେଖିଦଉଛି ମୋର ଖାଲି only request will my fervent prayer my lords they have despite your lordships oral observation that don't finalize the auction, they have gone ahead with the auction and auction I do not know whether sale certificate has been issued or sale is confirmed or not. Lord, they should come up fairly for my lords what is the present position. Lord, so that Lord, today my instruction is my client is ready to deposit.
But have you mentioned in terms of the previous order that how much?
We in our affidavit we have mentioned in our affidavit we have mentioned that upfront 30% amount will deposit.
7 crores some odd, and my learned friend's affidavit is that the petitioner submit that he is ready and willing to deposit 50% of the offered OTS amount by petitioner as per the bank's own letter dated 31/7/2025, 81 lakhs. And the letter itself 31/7/2025 that comes to about 7 crores some odd.
Yes. Lord, it is not that, Mr. Rao. 1 second, Mr. Kindly see my lord's order. What is my lord's order? And I have filed affidavit very clearly, my lord. Kindly see the order. You cannot dilute the order.
We have mentioned
upfront
that
yes.
Whether that
upfront, not the outstanding.
Well, let me argue my matter.
1 second. Let me. I am the petitioner.
Mr. We have mentioned in one paragraph,
sir,
that is last but one paragraph in page number 2
right.
of the last order, when we put a pertinent question as to whether the OTS offer amount was so is for all the loan accounts you wanted to.
That is exactly, sir. All the loan account that Annexure 10 you also referred to, that is dated 31/7/2025, you also look to that order. I have given that copy of the objection.
Is it any dispute that you have offered this amount?
There is a dispute, serious dispute. 7 crores some odd. The total amount comes in terms of that 31/75 that comes to 7 crores some odd. Para 8 also look to para 8.
No, that's right. We've seen. Come to page Annexure 10.
Yes,
but yes, so
yes, sir.
It says OTS offer amount of 2.7
sir,
crores
you also read
for
further.
full and final settlement of the bank.
Read further. I am reading that. 5 7 you also look to Annexure 7 page 55. Okay, just that is confined to 1. You also look to 35/7/2025. Annexure 1 at page 55.
Sale notice.
Is a sale notice. That is under 13.2. I am reading. We refer to the notice under section 13.2 of the Surface Act 2002 dated 6/7/2015 and symbolic possession taken under section 13.4 dated 14/3/2016. Paper publication done on 19/3/2016. Paragraph. In case you are interested in redeeming your property, you may repay the entire outstanding 2.2159 lakhs 861 along with the interest and other charges thereon, and may bring purchaser for purchasing your property minimum of reserve price fixed by the company authority on or before 7/8/2025 by 4 p.m. Now it comes 2,21,59,000 along with the interest and other charges. It is the principal amount. 2 crore is the principal amount 2012.
from 2016 till 2025, when the notice was issued,
Including interest.
include 7 crore somewhat.
No, we
and-
just, Mr. We just want a clarification. That is why we mentioned in that order like this. When you cannot dispute that this is your letter under annexure 10.
Yes,
And
sir.
it is dated 31/7/2025.
Yes.
And you have offered, OTS offer amount is 2.704 for full and final settlement of the bank.
This, also kindly see that is Messrs Mohabit Industries. That is in respect of one. The other ones consist of 7, that is page 55, order dated 5/7/2025.
Lord, let me clarify the position.
Sir, I prepared a date chart.
I think I think I am for the petitioner. Let me complete. Mr. Rautra will permit me to complete.
Just a minute.
Yes. Yes, yes.
Sir, I have no objection.
Please,
That's right.
let us do one thing. We are accepting the objection.
Right.
Copy has been served on you.
Yes, sir.
Please, we'll list this matter day after tomorrow.
Right, Lord.
Please, go through it and, we'll.
I'll come back to your lordship, my lord. My humble prayer is, my lord, let them not confirm the sale in the meantime, because if I am paying the entire auction amount before your lordship.
Sir, if you actually look.
One
to
second,
the-
mister, what is this? I am submitting, I am on my notes.
Asking me.
I am on my notes. I am making a submission before the court.
Just a
How
minute.
can you interdict?
Sir.
What is the status of the?
Status, sir, we have received 25% of the auction money. The auction purchaser had deposited that 25%.
Sale certificate has not.
That OTS, we have already considered the OTS and we have rejected that. It is not in terms of the
Kindly see,
OTS.
my lord.
Have you stated in the objection?
Yes, sir.
Lord, kindly see your lordship's order
Detail.
and kindly see the bank's conduct. Your lordship's indicated, your lordship, kindly allow, your lordship indicated bank to come out with an amount.
Sir, OTS.
One second.
Matter of right, sir.
What is this kind of quarreling in the court? Now I am saying something.
Just a minute.
Kindly see your lordship's order and conduct of the bank. Kindly see.
When, when you have, issued the sale certificate, how have you mentioned?
No, sale certificate has not been issued.
So that's fine.
Sale certificate has not been
Sale
issued. But no date certificate.
Just, no, we will not do. Sale certificate not issued.
Right.
Okay.
Sir.
second. Mr. Buddhadev Rao, sir, Land Counsel,
Sir, sir,
Senior
sir.
Advocate, appearing.
Just
for the
Dr. Kind.
opposite parties,
He is.
filed the
Excuse me.
appearance memo
Please.
and objection.
Sir, sorry, sir.
Filed
Sir, on
by the
14/8 it has been issued.
pursuant
Sale
to
certificate.
360.
And your lordship orally said don't finalize the sale. That was undertaking given to your
Sir,
lordship.
that is in terms of the.
Kindly see.
prior to the order.
Please have patience.
Sir,
The copy of the objection already been served, has been served today in court
yes,
on the Land and Council for the petitioner. The Land and Council, and Senior Advocate for the petitioner submits that the petitioner was has indicated in the affidavit that he is ready and willing to deposit 30% of the offered OTS amount as per the bank's own letter 31/7/2025. But all the same, the bank is proceeding to finalize the sale. When he put made a query to Mr. Rautrai about the status of the sale, auction sale, though in the objection, nothing has been mentioned that the sale certificate has been issued, but oral submission has been made in that respect. Put up this matter, on so and so, the sale certificate which is stated to have been issued in favor of somebody.
Highest bidder.
Who is that? Highest bidder. It will be brought on record. Is to be brought on record. He is not aware, how can you make him party, Mr. Raut? He is not aware that the sale has been finalized, sale certificate has been.
yes, sir, I have.
No, no,
told you that
you
also fine.
are yourself is not mentioning in the objection. You are in the question of his knowledge to make him as party. We are putting it day after tomorrow, and the sale certificates shall be produced in
No, no, I'm the auction.
with an affidavit indicating all the details relating to the sale, and of course the name of this one. So,
You have not, in the affidavit also, you have not disclosed who is the highest bidder.
They do it everything, sir.
I
I only pray, my lord, Lordship may protect to that till that date. No further action pursuant to sale certificate be taken given effect.
Sir, your lordship,
Kindly consider this, my lord. Yes, I humbly pray, my lord. I am paying the amount. Bank is interested about money. I will pay. I will pay, my lord. Kindly consider this, my lord. I will pay.
2025, we are approaching.
Yes, we will pay, my lord. My lordship may kindly protect me till that.
Question is that all these things, we did all this exercise because of referring the matter to the
Mediation, yes. And they are trying to frustrate everything.
and now if
Sir.
all these things have been done, so it will not be maintainable here. Now all these things that he has arranged as a party
Sir.
and the forum would be otherwise. So the question at that point of time, this was raised only for referring the matter. Now this has been done within a very 6th the order was passed.
Sir.
And we posted the case to
Sir,
now.
sir, even today, my lord, I have talked to the bank people. Even it has been, so far as the auction which was done, that is much prior to the receipt order, that notice was issued, the date. Please, 85% deposited. Now, sir, the only question is the amount, you also know that the total amount, it come to 7 crore some odd. If my non-friend told me in the morning that I have asked my client, if you are ready to deposit, I asked my client.
Kindly protect everything will be settled.
Yes, my client said that.
Yes, yes.
He has played mischief throughout.
Yes.
From item to 2012 to till date.
Yeah.
This kind of statement I have never made.
Mr.
This is not a statement to be made in the court. Unfortunate.
Mr. Rautray, suppose the man is now interested to clear up the dues which you have received from Mr. A.
Yes, yes, sir.
Let us say.
But the problem you have-
He makes the statement.
There are absolutely no, I have talked also to that effect to the bank. Suppose the amount which you have received from the auction purchase,
Right.
rest of the amount comes to this amount, total amount, that out of that 7 loan amount. So that comes to 7 crore some odd. If he is ready to pay and file affidavit with your lordship that I will pay this amount within 15 days, we have nothing to say. Sir.
3-1.
Yes,
He has deposited 25%.
sir.
Balance amount, balance amount according to you has already deposited and you have issued the sales certificate, that your oral version, which is
Right.
not mentioned.
Yes, sir.
So you make all those statement by day after tomorrow.
Yes, sir.
Yeah.
I'll give in detail, sir. How
The,
it will be realized and where from it will be realized? I'll give.
In the annexure A/1, annexed to the objection filed by the bank, it has that the property
Sale
in
certificate
question,
cannot be issued without deposit of full amount. You are saying 25% he has deposited. How
Yes,
can you issue a
I'll
certificate?
clarify everything. I'll clarify.
Mr. Rathra, this is the letter dated 11/8/25.
Right, sir.
So if that thing has happened, obviously it is after 11/8. The deposit of the balance amount, the issuance of.
He said.
After 11/8, kindly see, my lord. I don't think.
That is exactly what.
Let me make a statement that he has paid the entire amount.
He says on 14th he has done it.
So lekham, highest bidder is for 4.331 crore, out of which the 25% of the sale purchase price has been deposited with the bank. However, since Rautray and senior advocate submits that after 11/8/2025, the balance amount has already been deposited and sale certificate has been issued.
Yes.
All those materials are to be brought on record by way of an affidavit by the concerned bank manager, serving a copy on the land council for the petitioner, and the matter is to be listed on 20th August 2020.
So till that status quo agent will be maintained.
This matters, the property in question shall not be handed over till.
Right,
the day
right.
after.
So grateful, so grateful.
Item 9.
Late your lordship, my lord, the auction shall notice, my lord, that the petitioner filed this under
Liquidation interest rules 8(9). He then operated in Mumbai due to his oral cancer. I am interested to settle the loan. My lord, your lordship may kindly see.
We are
The only-
for this Grameen Bank.
My lord, only dues is, my lord, principal is 7 lakhs 46,000, but with interest they have calculated
But
45
all
lakhs.
these things you have to go there, not here.
Because petitioner notice, my lord, your lordship may kindly see by annex.
No.
He was admitted in the hospital for his oral surgery. my lord.
They are there and sick for some time. So
What I pray before lordship, my lord, I am deposited 25% of the auction amount, my lord. And in the application for one-time settlement, they may consider till then the auction should not be finalized.
reaction, we cannot fund the
My
matter.
lord, your lordship may kindly see, when the notice has been issued, the loan amount only 7, your lordship may kindly see.
When it is to be done, what is the date?
Date is, my lord, 19, my lord, tomorrow.
So
My lord, your lordship may kindly see.
date, you see the date and time of e-auction is mentioned on 19th.
Yes, my lord.
So tomorrow is the date and you approve the bank for that. You can keep it day after tomorrow, you apprise us this, what is the e-auction.
My lord, may I pray, my lord, your lordship may kindly
No.
stipulate, already.
Suppose it fails, matter is different, but if otherwise it is not maintainable here.
My lord, I understand, my lord, that,
No.
that your lordship may kindly see. The notice, your lordship may kindly glance only, notice at page
Whatever it may
21,
be, once it
19.
is held to be not maintainable, you have alternative. Otherwise you have to
Amount
wait
is,
for
my lord,
the-
only amount is, my lord, 7 lakhs, some order,
Right.
that is,
We are not amount even if, let us say 100 rupees, once it is not maintainable, it have to go to the, so.
What I pray, my lord, taken a
The writ petition has been filed by the petitioner challenging the e-auction sale notice dated 30/7/2025. There is no dispute that in view of the availability of the alternative remedy, this writ petition is not maintainable. However, the e-auction sale is posted to tomorrow, that is on 19/8/2025. The petitioner seeks for an adjournment till day after tomorrow to apprise this court about the result of the e-auction put of this matter on 20th of August 2025.
I may be also file a application before the bank, my lord.
କିଛି ନାହିଁ ଆପଣଙ୍କୁ ପ୍ରେୟାରରେ ଖାଲି ରଖିଛୁ ଆଉ କିଛି ନାହିଁ. Yes,
There ଅଛି, but I am mentioned, my lord, your lordship may kindly see.
next order.
Same, my lord, dita.
ଚାରି ବି ଡେଟ୍ ଥିଲା ସେଇଆ
Dita ka.
28/2025. Yes, next.
Because the petitioner is operated and he is discharged from the Mumbai hospital on 4th August, my lord. He received the notice at that point immediately.
Go and whatever you do with the bank, sort it out.
Your lordship, liberty may granted to move the bank also in the meantime, my lord.
There is no liberty once it is not entertainable, not entertainable. Yes, next 11, item 11.
Item 11.
That is why contempt petition has been filed. Willful disobedience of the order dated 21/2/2024.
But in this case, what one public interest litigation, the order was passed. On that basis, they are made an representation. And against that, he has come forward, that is the contempt petition.
That was relating to
That
the Koraput medical.
That fund is allocated, some people started for the land.
Legally enforce the land from Koraput. It is from Khordha.
And they are, on that basis, they are filed that contempt petition that they are.
Where is the direction?
They are not filing the petition before this one.
No, it's not necessary, but it's in the
Page 16, it's my lord's glance that
Mr. Jensen was issued.
Page 16, paragraph 23. Since 7 of the OPL Act has made provision summary evidence of the person unauthorized occupying the government land.
Yeah.
The OPL Act is a self-contained code and also provided the person occupying the land, any land, which is the property of the government, shall be liable to pay levy by way of the assessment of the carried by the Tahsildar. There being a clear statutory provision under Court of Appeal Act, we are of the view that once an unauthorized occupant of the property of the government is brought to the notice of the magistrate, or if it comes to the know, about the existence of the obstruction, public nuisance, and enumerated under section 130 of the code. The magistrate is illegally duty bound to show into the action.
Yes, accordingly,
According
have
to it,
issue these directions.
followed by the concerned following terms.
Yeah,
Once a district magistrate or subordinate magistrate, any executive magistrate, specially empowered by the regards by the state government, receive an information on the basis of the report of the police officer or otherwise that condition precedent exercise of power under section I of the section
133C.
and present the magistrate shall be once make a condition, order or removal of obstruction or nuisance from the public place, and it will be the border by duty of the person who may be natural person or a justice person such as a municipal body or gram panchayat to either comply with the order or appear in the proceedings, and upon the appearance of the proceeded, the magistrate shall be duty bound to ask the proceeding if he wishes to deny the existence of the fact leading to the conditional order. The proceeded deny existence of any unlawful obstruction of nuisance on any public place or from any way.
This order is meant for not complying. This order was passed on 21/2/2024.
Thereafter, you are to carry out all these things. Have you brought this matter that if there is any kind of obstruction over the public place or nuisance has been so?
What have you done?
It has. Have you whatever done? What is that? Who has filed this?
That order was in respect of the.
Whatever, there is an order. It was brought to the notice of this court. There is an order of division bench of this court. Right. Are you suggesting that this order is not to be complied? It has to be complied.
That hasn't
then complied. Then file an affidavit. Say what have you done?
This application, you see, the application is under Annexure 3C. It is addressed to the collector, and that has been filed under section 133. And the plot number, khata number has been given, and the name of the applicant is Dilip Kumar Samudra, who is obviously the petitioner in this case. And he has stated that you are to remove the obstruction / enforcement more than 3 acres of the government land over such and such. So this petition was filed on 10/9/2024. So what is the status of this proceeding?
Take instruction on that.
Take instruction, and you are telling that how this is
comply.
It's a general order has been passed that wherever the government property is under the so these things can be brought to the and the action is to be taken in accordance with the procedure that has been laid down under 133 CRPC. Notice has to be issued, and you are to be satisfied as the plot involves a government land or not. So thereafter, but you cannot sit silently once because that order is very clear that what you are to do once you receive such a application. So his grievance is that he has submitted the application on 10/9/2024. In spite of that, no action has been taken. This contempt petition has been filed by the petitioner Dilip Kumar Samudra for initiating the contempt proceeding under the Contempt of Courts Act against the opposite parties for willful violation and non-implementation of the judgment dated 21/2/2024. So and so. After receiving information regarding encroachment of the government land, with a further direction to the opposite parties to take appropriate action on the application dated 10/9/2024 in accordance with the said judgment in a time-bound manner. On perusal of the judgment passed by this court, which is annexed division bench decision by this court, which is annexed to the contempt petition as annexure 1. It appears that in the operative part of the order, it has been held as follows. Paragraph number 25 in entirety. It appears that the petitioner submitted an application under section 152 of the BMSS 2023, which corresponds to 133 of the CRPC, for removal of obstruction or nuisance from the government land over Khata number 687, plot number 834, area acre 29.07 decimal in Kumbharvasta Moja under Kurda Tahsil in the district of Kurda. Our grievance is that no action has been taken on such application. Even though more than, what is the date? More than 8 months, more than 11 months have been passed in the meantime. Stop. The London Council for the State seeks some time to obtain instruction about the status of application submitted by the petitioner under Annexure 3 series. Put up this matter in the week commencing from 1st September 2025. Free copy of the order be handed over to the Land Council for the State. Yes.
Item 12.
Well, at item 12, I have instruction from the appellant to appear in this case. Well, I have yet to file the.
You have to appear for?
Appellant. Well,
I was appearing for my names may be deleted.
well, I have yet to file the plea.
I was appearing for the original writ petitioner. It had gone to the Honorable Supreme Court. I think it has been remanded.
Yes.
Now my learned friend appears.
Flag X is the order of the now SLP.
In the writ appeal, what order has been passed till today?
The writ appeal was dismissed on 10/11/2022.
10/11?
2022.
Yes.
Thereafter, the Apex Court and the Honorable Apex Court has passed that order.
Where is that order? Order of the Honorable Apex Court.
Flag X, my lord. Remanded back to the High Court for
But in the operative part, it is mentioned that since the respondents have not entered appearance before this court, the High Court is requested to issue fresh notice
Yes, my lord.
to them and secure their presence before deciding the matter afresh.
Right.
So, the council says that he is entering appearance on behalf of the petitioners. So once he enters appearance, we can think of issuing notice to
Yes.
the opposite parties. Because there are some private opposite parties
Yes, my lord.
added as opposite party number 5, 6, and 7. File your wakalat number.
My lord, within 1 week, I will.
What is the name of the council? You will file or somebody else?
My lord, I will file.
Okay, give the names once.
My lord, in the Supreme Court's order, my lord, there is a status quo.
File first appearance, file your wakalat
Yes.
number. And the order of the Honorable Supreme Court
From 7 of the
when this order was passed on, because it was directed to be decided within 6 weeks. Now, when that order was passed?
24.
24. my lord.
So,
29
29 July 24.
First time it is listed here.
Yes.
Yes.
right, this matter has been listed first time after the disposal of civil appeal number 8073 of 2024, wherein the Honorable Supreme Court has remanded matter for fresh adjudication. So, though Mr. Ramakant Mahanti and Senior Advocate and his associates were appearing for the petitioners earlier in the writ appeal. But it is stated by Mr. So that they have instruction, he has instruction to appear for the petitioners in this writ appeal. And he will file his wakalatnama within a week. In the order dated 29/7/2024, the matter was directed, notice was directed to be issued to the respondents. Press notice, directed to the respondent, and the subject controversy to be decided by this court within a period of 6 weeks. With a further direction that the parties to maintain status quo till the matter is decided by this court appraise. However, since the matter is listed today for the first time in the Land Council, so and so is seeking for an adjournment for 1 week to file his wakalatnama. Raise this matter on 26th, on 1st of September 2025. If any wakalatnama is filed in the meantime, the same shall be placed on record and the names of the Land Council for the petitioner be reflected the cause history.
Our names may be.
In any case, we have also.
But who please to file the requisites?
No.
This,
Without requisites.
but how can we once he has
Without proof notice. No, without.
stop. The Land Council for the state, in view of the order of the Honorable Supreme Court, the Land Council for the state accepts notice on behalf of the opposite parties number 1 to 4. And the registry shall issue notice to the opposite for 5, 6, and 7. By day after tomorrow, fixing the date of their appearance on 1st of September 2025. The notice shall be served on the Swansea to the inspector in charge of Oak Police Station. And the compliance report shall be filed on the next date. The Land Council for the state shall pass necessary instruction to the IAC Oak Police Station in that letter.
Our names may be deleted.
The names of Mr. Ramakant Mahanti and his associates shall not be reflected in the cause list henceforth. Yes. Okay. The status quo for them, the status quo as on date shall be maintained. In view of this one, so for the last operative part of the people. The parties shall are directed to maintain status quo till next date problem. Yes. Okay.
Item 13.
Oh my lord. This in view of the direction of this court, noticing. Semi-field petition filed for the registration of restriction.
We commence not being first time. Is this matter on file? Yes.
Semi-field petition, my lord, is filed with person of restriction. So considering the.
No, some defect is there. What is the defect? 6B, yes, of provision of law. Absolutely. It was dismissed. Yes. What is that order?
In the writ petition also, you have not cured the defect, therefore the court dismissed it.
In spite of receiving orders, one should not be sued.
After restoration of this, after restoration of the restriction, thereafter I will remove the.
You remove the defects. Now, we are telling that then we'll, otherwise, again, the matter will be reverted back and you will not.
After removal of, after.
You just file the requisites or the remove the defects.
Yes.
We'll see that in the writ petition and then we'll do the needful. In CMAPL, who are the parties? So the state is the parties can be done. There is no problem in that.
Yes.
The CMAPL has been filed for recalling the orders dated 31/10/2019 passed by this court. And in which the writ was default, for non-removal of the defects as pointed out by the office. With a further prayer for restoring WPC number so and so for adjudication. The Land Council for the petitioner submits that he will remove the defects in the disposed of writ petition. First, and produce the relevant document by the next date to praise the CMAPL. Put up this matter on 1st of September 2025. Clear?
15, 14, 15, 16 also same.
Sufficient. The 13, 14, 15. Just for the so and so is restored subject to the removal of the defects and the within a period of 2 weeks by the petitioner. CMAPL is disposed of. Okay, assume.
दुई टाइम दिया आपन को जो writ petition रे defect क्योर अच्छी defect गुड़ा क्योर करिए.
Yes.
And it is restored. Otherwise,
CMAPL will stand.
Without reference to the court.
Yes, next.
My lord, kindly pass over this matter.
Amendment. What amendment you are seeking? The correct number of degrees. So amendment is that prayer portion that the delay has been correctly not mentioned earlier. Now it has been mentioned that delay is 970. So we are permitting you to correct it in the prayer portion. The IA number 147. No, IA number 245. 245 of 2025. There is an application for amendment. For correcting the number of days delay in filing the CMAPL as mentioned in the delay condonation application. That is IA number 147 of 2022. Who is appearing for Government Bank?
I am appearing.
The land counsel for the bank has no objection to the same. Accordingly, what is your name? Give your name. On behalf of me. Sworn to appearing on behalf of Mr. Lalatendu Sama. The prayer is allowed. The land counsel for the petitioner shall file a consolidated interim application.
Consolidated already filed.
Submit that the consolidated interim application has been filed, indicating the delay of 979 days in filing the restored stock. The consolidated petition copy has also been served on the land.
Consolidated IA. Consolidated
The
IA.
the consolidated interim application has been counsel for the land. Do you intend to file any objection or will you restore it?
I have filed the objection regarding.
You intend to, the land counsel for the bank submits that he may be given some time to file objection.
I have filed the objection.
Already objection filed.
Objection already filed.
Lordship had had this, but on many occasions, objection was filed. Lordship were pleased to allow that, but because of the date, Lordship were pleased to direct me to file an amendment.
All right, the land counsel for the bank has already filed the objection. After hearing the land counsel for both the parties and going.
Your Lordship, may I 10/3/2000 10/3 order your Lordship may say.
10/3.
10/3. 10/3 to that is on 10/3 order. The last but two paragraphs is there. A report was called from the registry.
Your writ appeal was dismissed because requisites were not filed.
Yes, but I have taken a government that requisites were filed in time.
That is why.
That is why Lordship had called for a report. After going through, Lordship were pleased to take a loan, sir. So Lordship were pleased to allow the CMFL dictated the order. But at the same time, Lordship found that the dates I mentioned in the delay petition not very. So that's why Lordship allowed me to file an application for amendment.
Delay condoned and the job is to be restored, Mr. Samudrai. CMAPL is allowed the order 21/10/2019.
No. 29/8/2022.
Order
by which it is.
Yes. Okay. The CMAPL was also dismissed earlier.
Yes, sir.
So that now
The first CMAPL has been allowed since long enough. Thereafter, the second for restoration of the CMAPL, the previous CMAPL has been allowed since 1 year back. And this is the present CMAPL for restoration of the CMAPL.
Just a minute. The present CMAPL is CMAPL number 324.
Yes.
Okay, let us see that CMAPL 324. And your prayer is to set aside. That field will now be restored. That CMAPL number
440 of 22.
That has been restored since long enough. That has been restored. Now you also will take up the CMAPL 324.
Oh, then now if we take up this CMAPL 324 of 2022, yeah, of course, that is to restore the order dated peremptory order dated swans. Okay.
No.
All right, this WA, Writ Appeal number 371 of 2019 is restored to file. All right. The CM appeal is disposed of. This next.
Item 18.
There is a lots of delay. My friends were supposed to file an objection to that.
Today I am filing my objection. I'm serving my. I'm serving the copy to my learned senior.
What order you are
Same, the Writ Appeal was also difficult because due to also look at it.
Writ Appeal hଉଛି କାଇଁ Writ Appeal କେବେ decide? 9/2020.
Writ Appeal number 5.
ତା ଦେହରେ ଗୋଟେ କଣ objection କଣ file କରିବି?
ସେ delay ଟାକୁ
Delay
objection
of 760 days, man.
ଆଉ ହେଲା ଆଉ କଣ? delay condemn କରିଦଉଛି.
Pay some cost to bar.
I'm ready.
You
I will
must
happy to pay.
In two matters you are.
I will be happy to pay.
The CMAPL number one, so IN number one, so this is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 760 days
Yeah.
in Swansea. The Land Council for the Union of India has filed objection to the delay condonation after hearing the Land Council for the petitioners, also the Land Council for the Union of India. We are inclined to condone the delay in filing the CMAPL. The delay is condoned. The CMAPL order for them. The CMAPL has been filed by the petitioner for order dated 28/9 though.
28/9/2022.
28/9/2022, wherein the writ appeal was dismissed for non-prosecution. The after perusing the grounds taken in the writ appeal and hearing the Land Council for both the parties, the writ appeal is restored to file, subject to kete phone Bar Association Welfare Fund.
Whatever, my bar notes, I will not hesitate to pay.
10,000.
5,000 could be.
All right, 5,000. 5,000.
When the earlier petition,
Yes.
you escaped not to cost.
Take 5,000 କରିଦିଅନ୍ତୁ plus I will happy to pay plus
Delay ଟା ଯୋଉଟା ଅଛି ସେଟାର 5,000 ଏଟାର 5,000
ଆଜ୍ଞା
ହେଲା ଏଇଟା High Court Advocates Welfare Fund yes time ଦେଇ ଦିଅନ୍ତୁ 1 week କରିଦଉଛୁ
ଆଜ୍ଞା 1 week ସେ ଫାଷ୍ଟରେ 1 week କରିଦିଅନ୍ତୁ ଆରଟାରେ 2 weeks କାରଣ ଫାଷ୍ଟ ହଉଛି କଟକ ପର୍ସନ ଆଇ କ୍ୟାନ୍ ଇଣ୍ଟିମେଟ୍ ହିମ୍ ଦ ଅଲରେଡି ଯେ
okay
କନଷ୍ଟେବଲ ୱାର୍କିଂ ସମର ସୋ
interim application ଯୋଉଟା condonation of delay
ଆଜ୍ଞା ସେଟା 5,000 ଟଙ୍କା within a week
ସେଟା within 1 week ଆଉ ଏଇଟା କେବେ
ଏଇଟା sir 2 weeks
2 weeks ଅଛି second ଟା 2 weeks we are just coming with it
What's your mind? Interim application for amendment. Already served, no reply has come. But interim application amendment has been filed because in the meanwhile.
Just a minute, IU number 115. Oh, it's just IU number
11588.
11588. Very good observation. Click on. After what is this writ petition for?
That's, I am a purchaser, Milox. I purchased a land that was auctioned by the opposite part number 1 bank. Not since 2022, they have issued me a confirmation of sale.
Oh.
In 2024, 12th, in the month of March, they issue me a subsequent confirmation. Then after they call him and ask him to pay the deposit, pay the money. He pays it. Now they are saying they are not taking my interest. My amount is pending with them. They are enjoying it. Now this has been held illegal by the Honorable Appeals Court in Cellular LLP. The judgment of Cellular LLP versus Bafna Motors. And that says that it cannot be done. Once the confirmation of sale has come down, there is nothing that can be entertained. In the meanwhile, they have entertained his application and allowed him. I have challenged that. It is at annexure P1 of my interim application. It was only introduced by a counter affidavit. Yes, please.
An amendment is the subsequent development, my lord. So no objection. IU number 11588 of an application for amendment of the petition. Copy of the inform application has been solved on Mr. Biswal and counsel appearing for the bank. For the borrower, my lord, I am for. I am for the borrower, my lord. As a bank paying. Mr. I am for the office number 3. Okay, Mr. Mahanti for the bank.
OP 1 and 2.
And opposite party number 1 and 2.
1
And Mr. Biswal for opposite party number 3.
For it that, my lord. It is for that reason they have realized and taken money from me. My wife is the actual borrower. He has died. She has died.
For no objection regarding the proposed amendment. Accordingly, prayer is allowed. The proposed amendment now shall form the part of the writ petition. Grant counsel for the petitioner. Have you filed that consolidated writ petition?
We filed it in 2 days.
Submit that you'll file the consolidated writ petition.
We did 2 working.
Okay, by Wednesday, for them. Matter be listed, serving copy and the land counsel for the opposite parties. So matter be listed on 1st of September.
But how have you implicated a dead person?
I didn't know his dead. See, no, they have
Now, since he is bringing to the notice, you have to bring a large of.
Borrower has disclosed that.
we did, bank also did not know.
Now you know.
Now it is significant to know that I am the.
Now they are saying that this is.
Land counsel for the opposite parties, so and so. Submitted that the opposite party number 4, Dr. P.T. Naik is dead. And counsel for the petition seeks some time to obtain instruction in that respect and take necessary steps for substitution of the LR of opposite party number 4. Yes.
Item number 20.
I am much opposite party. My the petitioner challenged that 13(2) of the Supervision Act notice as on the ground that it is a cooperative bank. Cooperative bank which is maintainable.
Wish for
This is
the
the judgment file, you will.
petitioner,
Pardon, my.
wish for the petitioner.
This is the judgment file, you will.
Wish for the
It is
petitioner.
also applicable to the property bank. Preparation act is applicable to the.
No, Mr. Mahanti, we just want to hear from the petitioner why it is pending since 2009.
Petition is not.
Any order was passed.
Yes.
This is in a period of no course of action shall be taken
Taken.
against the petitioner. So, 2009 পরে how it has seen. Nine. After 2009, it has not been listed. It is listed for the thereafter for the first time.
This is, he is challenging the notice.
Notice, 13 to notice.
13 to notice.
Dispose of non-appeals for the petitioner.
No, no, but which is a cooperative bank. Huh?
Cooperative bank it is
Maintainable.
Yes, the applicable judgment. That is in the 2020 volume 9 SEC 215. Panduranga Ganapati Chowgule versus Vishwanath Vishwas Rao Patel.
Cooperative society.
Yeah.
Cooperative society is also a financial institution.
That after section 70 of the act, arbitration.
2.1, last page you will also thanks.
Last page of the judgment.
Last page of the judgment, 142.1, 142.2, 142.3.
Para 138. Para 138. Banking relating to cooperatives and being through within the purview of each particular city or unit of the
Considering part 142.
142.3, the cooperative banks under the state legislation and multi-state cooperative banks are banks under section 21C of securitization and reconstruction financial assets and Security Interest Act 2004. The recovery is an essential part of banking. As such, the recovery procedure prescribed under section 13 of the Supply Act, legislation related to Schedule 7, List 1, Entry 45 of Constitutional India is applicable.
I found challenge little. The petitioner sponsor has filed this writ petition challenging the notice issued by the Zenkanal Organ Cooperative Bank dated 31/2008. Stop. The non-appears for the petitioner, the land counsel for the you are appearing for whom, Mr.
Bank. Zenkanal Urban Cooperative.
Appearing for the opposite parties number 3, 4, and 5. Right. And submits that place the citation in the case of so and so and reported in so and so, but in paragraph number 142 it has been held as report for the entire song. 142 last page I use this center agent figure paste for in view of the fact that the petitioner has brought alternative remedy available and moreover he is not present. And it's a matter of the year 2009. The petition stands dismissed. The interim order dated so and so 16/11/2009 passed in this case number so and so stands vacated. Yes.
21 7. 21 7.
Item number 22.
I have received the counter affidavit from the opposite party.
20 or 21 same order.
There are two cases. In first case, my land in Mr. Siddhartha is appearing, and in second case, I am appearing for the petitioner. I have filed, Union of India has filed, some of the officers of Union of India has filed this writ application. The opposite party has filed a counter affidavit serving a copy on 4th August.
Who is for the opposite party number?
Lordship, I am appearing on behalf of Mr. S.S. Das. I am for the opposite party. Lordship, in this case, I am praying for a short adjournment due to his possible.
Just a minute. You have filed your.
Yes, Lordship.
In 29485.
Acha. Right, the counter is on record. So what do you intend to do?
15 days time may kindly be granted to file a rejoinder.
Land and counsel for the.
In first case, I am appearing for the petitioner. In the second data position.
Land counsel for the petitioner. Petitioner, sir, na? Mr. S.S. Mahapatreta, the first लिखिए, Mr. D.R. Gupta in the second writ लिखिए, present and submit that he has received the counter affidavit filed with party number 2 and intends to file rejoinder to the counter affidavit and 15 days time may be granted. Land counsel for the opposite party number 2 is present. Put up this matter in the will commencing from 8th of September 2025. A rejoinder affidavit, if any, be filed in the meantime, serving copy on the land counsel for the opposite party number.
Obliged.
Yes. Okay, now we will purchase.
Item number 23.
Yes.
Had the matter extensively on that last occasion. Only on the point then, it was halted. That full bench judgments. That also I will address your lordships on that point. My lord senior is also there.
The last time I learned from the other side matter told that it has already been decided that your lordship directed to file that judgment.
But regarding the title, all these things, but that is not the fact, but he is saying that.
ସେଟା ତ ଆମେ କିଛି judgment ପାଇବୁନି.
No, it's Mahapatra said that he placed reliance on the case of full bench decision of this court.
And that is one aspect.
And further submits that the same issue was also before the Honorable Supreme Court in one of the proceedings. And Honorable Supreme Court has perhaps taken.
You have to submit that the issue of title pertaining to property in subject has already by the Honorable Supreme Court. Where is that?
No, I said that it was before the Honorable Supreme Court. That was filed a 37 petition before the commissioner. Commissioner dismissed that petition, allowed that petition against that.
Facts I have submitted.
No, not on this case. I have given the documents.
No, where is the judgment of the Supreme Court? You made a statement.
Yes.
In the open court,
yes, my lord.
This order.
Yes, my lord. I am conscious.
That and it relates to that particular also. We have stated.
Yes, my lord.
Thanks, it is okay.
These are these copies.
Supreme Court decision.
Supreme Court, High Court Commissioner at every stage he was a party. That matter went to the Supreme Court. After where Pramila succeeded.
In the writ petition, the commissioner consolidation order was challenged.
Yes.
Okay. And the learned single judge has passed the order. Against that learned single judge order, whether AP lies or not, that's the question. And because that was a petition under 227, not 226. That's the question. And the law is now settled. Just see, show the law.
The full bench judgment I have given in my.
A petition, a writ petition under 227, if it is disposed of by the single judge, writ appeal doesn't lie. If it is a petition under 226, single judge decides intra-court appeal.
That is 226 and 27.
No,
227.
No, that's just.
That is the judgment of the Supreme Court.
No.
I think in that judgment of the full bench, that Supreme Court judgment has not taken no. That
I'll place. Also that
No, no,
is in contest.
Regarding that, whether an appeal will lie, second appeal will lie from a special statute. I've gone through the judgment. If your lordship permits me, can I make a submission to distinguish that judgment?
No, why will not, if the property involved in this case, which is now the subject matter of course of the writ appeal, and some order has been passed by the Supreme Court, as you said, where the parties were also there.
Yes.
Why don't you give a copy so that the Land and Council may verify?
Yes, that I've obtained the certified copies. I'll give them copy.
Give them,
so that
then
in
or
that
not
case-
go into that maintainability.
I'll give my lords. What I'm saying, in that case, the matter was challenged by another person to record his name. That was rejected by the commissioner. Against that, we were all of us were party in that case. That came before this honorable court in a single bench. There also, the prayer of that petitioner was rejected.
No, this Namita Singh, the present.
Namita Singh was not there because by that time she had not purchased. By that time, Pramila was very much there.
From whom she purchased?
Whom she purchased. So Pramila was a party.
There is no dispute about that. No dispute over that.
I'm clarifying how the matter went to the Supreme Court. After our case, disposal of the case in favor of Pramila Jana, another Radhakrishnan there, he claimed and the property was recorded in his name. That was challenged by one Aditya Prasad Das before the revision, where Pramila Jana was a party and Osman Samantra was also a party.
No, but the property, if into that particular property.
Yes.
If you say that the Honorable Supreme Court has passed some order.
Yes.
It is better that it
that title has been declared in its favor.
Please go through it. So,
Yes,
What it says, let me clarify. It is a question that Pramila Jalna, while was minor, her father, without her consent, has sold the property. And that is in favor of that Asima Samudraya, for whom he is appealing. So now the question is that, but Pramila Jina, after became major, then sold the property.
all right, we are just asking you to hand over the copy
Yes,
of that Honorable Supreme Court decision and please go through it and tell us that whether that has got any connection with this case.
I've been asking.
This is not consideration by the Lord single judge. Not consideration.
No, I am not saying that.
Nowhere this is pleaded and nowhere this point was raised.
Se kaunta kouche
Oh, that
Not gone through, but he's making the submission. I have gone through it, I am making.
You have gone through it. ସିଏ କହୁଛନ୍ତି ଯେ କହିବା କଥା ସିଙ୍ଗଲ ଜଜ୍ ପାଖରେ ଏ ପଏଣ୍ଟ ଟା ତମେ ଅର୍ଜ କରିନାହାନ୍ତି
this point you have never heard.
ସୁପ୍ରିମ କୋର୍ଟରେ
ସେଟା ତ ମେରିଟରେ ଶୁଣାଣି ହବ। ବର୍ତ୍ତମାନ ମେରିଟରେ ଶୁଣାଣି ହେଲାନି କି ମୁଁ କହିଲି।
Find that it's a very relevant point which should have been brought to the notice of the online and single judge.
Yes,
which
yes.
has been to appropriate order can be passed, but first of all, just verify that whether it has connection with the case in hand. He is making a submission that the property was the subject matter of the proceeding before the Honorable Supreme Court and some order has been passed. Whether it has got
any connection or not, that my lordship will say.
ଆଚ୍ଛା ସେଇଟା ତମେ ତମକୁ ତ ମାଗୁଛି
ସେଟା ସାର୍ଟିଫାଇଡ କପି ସେ ଜେରକ୍ସ କରି ଦେବେ ଆଉ କଣ ଦେଖନ୍ତୁ Mr. Mahapatra and
ଆଉ ଗୋଟେ ପଏଣ୍ଟ ବି ସବମିଶନ ଫୁଲ ବେଞ୍ଚ ଉପରେ
material for the so far as the claim of my delay.
Submitting the copies of the judgment of the Honorable Supreme Court, and he will hand over the copies to the Land and Council appearing for the appellants.
And respondent number 4.
Also respondent number 3, na? Mr. Mahan? Respondent number 3.
Respondent number 4C and 4E.
As well as respondent number 4C to 4E.
4C and 4E.
4C and 4E.
Yes,
ପଣ୍ଡିତଙ୍କ ସାଙ୍ଗରେ କେବେ ଆର୍ଗୁମେଣ୍ଟ କରିବ
We commencing from the date they given. The Land Council for the parties shall apprise this court as to whether the Honorable Supreme Court decision has got any connection with the issue involved in this writ appeal or not? Yes.
So kindly give a time period so that he
Sir, ଗୋଟେ particular date
एक
କରିଦିଅ।
हफ्ता ଭିତରେ ଦେବେ ତ କହୁଛନ୍ତି ଆପଣ? Within
ଗୋଟେ
this week, with our copy.
Date may be
8 September ଆସିବ।
at certain top of the matter ଆସିଲେ ହନ୍ତା।
ହଁ ଠିକ ଅଛି 8 September 2025. Yes.
Yes, sir.
Item number 24.
Yes, Mr. Ghosh. Mr. Das.
Well, this is a,
Which for the bank?
well, he is for State Bank of India, Malad. Well, this is a peculiar case. Well, State Bank of India, Malad, came out with a public notice for the sale of the property after 13/4. I became the highest bidder. Then I deposited the amount. Well, no, so the initial amount that was deposited. No sooner it was done, Vijay Bank came before this order, challenging 13/4, not approaching under section 17, Malad, by saying that this property earlier was mortgaged with them, but they have not taken any action under section 30.
Who is appearing for Vijaya Bank?
Well, nobody is appearing. It was,
No,
I think Mr.
notice has been
Gajendra's,
issued.
Mr. Gajendra's name was there.
But
You are appearing for State Bank.
He is for the State Bank, Malad.
right now, nobody is appearing for bank, BJP.
But
Vijay Bank now, it doesn't work with the Bank of Baroda.
Acha.
But now this situation is like this.
No, because whatever you say that he is a necessary party, but if notice has not been issued.
But the lawyer, Mr. Gajendra, was appearing and his name appears also.
You are caught between two banks.
Lord, I am caught between the devil and the gypsy.
You paid the money. You get out of this mess by taking your.
Well, I said it's a peculiar case, fellow. And what happened is, this Honorable Court entertained the application of the Vijay Bank and passed an order. First granted interim order. Then the order was that since it is basically a dispute between the two banks, so let there be a committee. Committee comprising of one member from the State Bank of India in the higher in the hierarchy, and also Vijay Bank. I believe the committee was formed, and they had not two sittings, but nothing came out.
Nothing came out.
Nothing came out.
I have the minutes of meeting.
Sir.
No, say yeah, but thing is that when the Vijaya Bank is now going on represented because
They have to come, not they them from their side have to come, Malad.
But
if I understand, Malad, the amalgamation or merger, then what really happens is, Malad, on merger of one company or one bank with another, then the company which gets merged with the other one, then automatically other one has to come. If they don't come, Malad, I have made the entire deposit since 8 to 9 years. The whole of the consideration money has been paid by me. And State Bank doesn't dispute because they are the people who came forward under section 13/4.
Where's the property? Where is it? You are insisting for the property or want?
No, I want the property because then way back when I have given the entire money. And now Milad in Bhubaneswar, anybody who has little bit of sources will definitely hire for the property, not for the reform Milad. And Lakshmi just sees, I paid Milad.
But there is nothing on record that the notice on this Vijaya Bank 3 and 4 made sufficient. We do not know.
Your Lordship Milad on the last section directed Milad for newspaper publication on the private party whose property was in fact seized.
Private party.
That has been Milad complied with.
About this 3 and 4.
Yes.
Nothing is on because.
And Milad, in fact, Vijay Lordship will just see the order, just showing to your Lordship's order, Milad.
There is an order that somebody entered appearance 3 and 4. S.K. Gajendra, right? He
Yes.
is appearing, so his name is there, no?
Yes, exactly. His name appears in the list.
Okay.
And it is him, my lord, who in fact filed the writ application before this honorable court for them.
What is the wakalat nama? S.K. Gajendra.
Lordship, just see page 30, my lord.
Go to that. Sarat Gajendra. His associates' names are there or? What about the associates of Mr. Gajendra and his associates?
They are not appearing, my lord, now. Mr. Gajendra is the senior advocate, my lord.
No, he is.
He is coming regularly, my lord.
Oh, few days back, one matter he is not well, William.
Yes, he is coming regularly, my lord.
He's from Bhubaneswar, no?
Yes, yes.
So that is the problem. Might not.
I don't have a problem, my lord.
Huh?
I have no problem.
No, that's it.
I recently have changed my postal address.
Can we keep it day after tomorrow and just give a ring to Mr. Gajendra? Can, because.
But we did have some difficulty, my lord.
Just.
File wakalat now.
No. In one matter, it was mentioned that he is not well. That is how we are making this.
It's not well, I have told you.
Just few days back. No, the number. The number. They all of them are his associates. So.
Devi Prasad Das. Devi Prasad Das.
By the way, we pray, matter may be taken on first week of September.
No, just to give the intimation, all right, there is no problem. He can appear through virtual mode also, argue the matter. But as Mr. Das has rightly pointed out that he used to come and appear in depth. But I think a week back it was mentioned that he's not well in a particular matter. So that is how we,
In fact, my lord, on the all last 3-4 occasions when this matter got listed, there was no representation on behalf of the Bizarre Bank. And he is not appearing also last 3-4 occasions.
That's why we just want to take it this matter day after. Just if we can give a ring, that must get the number. That number can be available. There is no problem, I think. No, you can get from the bar.
No, that I believe we can, because we are in the seniors lounge, we have a group, we are in touch.
We are just taking it to day after tomorrow.
Well, not 20th, to 21st.
No, 21st is a different board is already there. So for that, 22nd it can.
Yes.
Mr. S.K. Gajendra, land senior advocate, who is appearing for the but 3 and 4 Vijaya Bank is not present. Mr. So the last line, senior advocate appearing for the petitioner. So also you are appearing for whom? So also the land council appearing.
For state bank committee. The starting of state bank committee.
You are Mr. S. Sarangi.
Yes, sir.
Mr. S. Sarangi, land council appearing for opposite parties number 1 and 2, no?
1 and 2.
For state bank president. we are not writing anything to intimation, just is a formal.
Yes.
On consensus of this matter on 22nd of August. All right.
Well, this is, I think, I have never come across such a case. One bank filing against another.
No, you see, maybe he has, the man is very cunning, so he
Yes.
has
Created chat in both the banks
with
and.
both the banks and yes.
That is why he is not appearing well.
Yes, next.
Petition number 25.
Member, President of India, approving the order of the Central Administration.
He is appearing for the Union of India here.
Sent today because of his illness, madam.
Who is?
Madam, Satya Sindhu Kashyap, Senior Penal Counsel. He is ill today. But I have been.
The name of Mr. Sahoo is mentioned here. Dhanush Kumar Sahu.
Madam, it has been allotted to Mr. Kashyap.
They have engaged.
From Union of India, who is supposed to argue this matter, just tell us the will record.
Madam, Mr. Kashyap, madam, Senior Penal Counsel, Satya Sindhu Kashyap.
Satya Sundar.
Sindhu.
Satya Sindhu Kashyap.
Kashyap.
Is the
Senior Penal
Counsel.
Again.
Okay. Mr. Land Counsel for the petitioner is present. However, it is stated that Mr. S.S. Kashyap, with the Senior Panel Counsel and supposed to argue the matter for the Union, is not well today. And you want it day after tomorrow or any other date?
Madam, day after tomorrow.
Next week.
Acha. Not well. Land Counsel for the petitioners submits that matter may be listed a week after. Next week, we are not placing the case because one day is for that day and only one day is left because the other day has been declared as holiday. So we are bringing it on first. All right. 1/8/2025. Yes, next.
Item 25.
25 Galapan?
26. Item 26.
26.
Made legal issue involved one list was prepared in order to give upon compassionate ground.
Writ appeal against the order of the land single judge.
Something.
What is that order? Annexure?
That is annexure 8, you got
8.
Page 81.
Okay.
Relevant page 83.
What was your prayer in the writ petition?
To give me appointment on compassionate ground as has been given to others.
So why it was torn down by the land single judge?
Your Lordship will.
What is the reason?
Reason that I have not completed.
Come to the relevant paragraph.
Yes. Your Lordship can say. At this statement.
Who paragraph to Poduchandi? Who
page 83, your Lordship will see.
83. Yeah.
Annexure page 83. It may not be.
83 the order, entire order.
Last paragraph, that is, it is at this stage, the Satyabrat one alone council appearing for the corporation brought to the notice of this court, the development through WPC number such of such, a writ moved earlier at the instance of petitioner himself and
Orissa Lift Irrigation Corporation.
Okay. Observation therein, the Mohanty Learned Council for the corporation that already a benefit.
Who was employed and who died and.
This is not case of death. This is a case of invalidation. My father was a mechanic in Orissa Lift Irrigation Corporation.
Okay.
My lord, thereafter medical board was convinced and he was declared incapacitated.
Okay.
Then appointment was given retirement on invalidation ground. Thereafter, your lordship.
And this rehabilitation assistance scheme also covers that.
My lord, covers that. I have after that. That is
All
the
right.
record.
Just we want to know.
My
Yes.
lord,
Then
thereafter, your lordship, what happened? The corporation prepared a list.
no, you
My lord.
पढ़ो तो अपन उधर भी गए.
A writ petition was moved thereafter, your lordship. My learned counsel for the corporation contended that already a benefit granted to the father of the petitioner on the condition that well, that it starts begins with it is
out it is at this stage.
state. The Satyavrata Mahansi learned counsel appearing for the corporation but brought to the notice of this court the development through WPC number 2187 of 2009. The writ petition moved earlier at the instance of the petitioner himself, referring to the observation therein from Mahansi, learned counsel for the corporation contended that for already a benefit granted to the father of the petitioner on the condition that there shall be no extension, rehabilitation assistance of his legal heir, the petitioner is stopped to claim an appointment under rehabilitation assistance scheme. Considering the rival contention of the party and going through the order dated 8/7/2009, passed in WPC number 2187 of 2009, this court finds this court, while considering the writ petition, directed the authority to take a decision on the rehabilitation application of the petitioner has made following observation. In view of the fact that corporation, while granting post-fact for retirement of S.K. Abdul Hanan, mechanic lift irrigation division, Kendrapada, with effect from 29/7/1997, has specifically directed that no rehabilitation assistance scheme for employment of his legal heirs will be allowed. We are of the view that the petitioner cannot claim compassionate appointment under the said rehabilitation assistance scheme as a matter of right. Reading to the aforesaid observation, this court finds the father of the petitioner was given post facto sanction of retirement on condition that no benefit under the rehabilitation assistance will be given to the legal heir. It is for the clear observation and a condition attached involving the father of the petitioner taking post facto sanction of the retirement. This court finds petitioner is stopped making any further claim in the matter of rehabilitation assistance. In the circumstances, this court is not inclined to entertain the writ petition, which is dismissed accordingly. This is the findings of the learned single. My humble submission before your lordship is this post facto approval, your lordship, is to see that is in each and every case the same language is given. Next 9, page 85. Next page. That is in case of another employee. Post facto sanction is hereby accorded for retirement.
Where are you reading?
My lord, that is page 85, annex 9. Did my lord get it?
Yes.
My lord. Post facto sanction is hereby accorded for retirement, a relief of MD Jalil, senior pump driver of lift irrigation division, Kotak, with effect from 1/8/1987, who has been declared incapacitated by the Chief District Medical Officer, Kotak, for further service. No rehabilitation assistance scheme for employment of his legal heir will be allowed for the present. This particular word is very important. For the present, learned single judge and your lordship.
It's a case of another employee.
Another employee.
What
Who is
happened?
also in my list. That is one list was prepared.
Has he been given?
Yes, my lord.
Where is that?
That is your lordship, kindly see.
Jalal.
The writ petition, that is your lordship will see. Page,
What is his name? Mr. Muhammad Jalal.
my lord. That is your lordship, just have a glance. That starts with 40.
40.
My lord, 40.
Oh.
Of the writ petition, your lordship, annex of 30. In the writ petition,
Acha, writ
in the running page, your lordship will see 40. That is a list your lordship given under the heading list of applicant under RS scheme on invalidation ground.
Good, no?
Petitioner co-annexure.
Writ petition.
That is my
Writ petition consists of 29 pages only. There is no page number.
running page your lordship.
Co-annexure.
that is Annex 13 of the Writ petition Annex 13 diagram.
Information provided.
The information provided.
Provided.
List of 27, page
Ah,
27. Yes, yes.
If you put a list that is they have prepared.
Yes, 27.
List of applicants under RSP on invalid.
Jalal put
Jalal.
Second page 41, serial number 34 is petitioner to be considered.
41.
34.
34 Mohammed Rizwan to be considered.
35 होती MT Shakil जो Annex 9 है हम देखेंगे.
To be considered.
To be considered. But in the meantime, all have been given except me. And what is the reason why I was not given? That is your lordship kindly see. That is in the page 39, running page 39.
To be considering consider Higalani will put again.
Again,
That is not there in the at least in the single judge order, that is not there.
My lord, not
Upon a claim of
नहीं आपन रिक्वायरमेंट काई एसके जलील को अपॉइंटमेंट हला केबे हला कोन
Similarly situated जदि अब आपण अपॉइंटमेंट नेबे होइतले आपण अमेंड करथांते रिट पिटिशन it is to be considered आछि.
My lord, all of them have been given. Your lordship.
काई अमेंडमेंट करथले रिट पिटिशन
नहीं इधर अच्छा
रीट अपील ले
paragraph
रीट रे नहीं
B. Paragraph B.
When they were appointed after the disposal of the writ petition or when?
That is your lordship.
When these two people are 35,
My lord.
Jalal and Shakil
My lord.
have been appointed. Date.
If it would have been after the disposal of the writ petition, it's well and good. If it is suppose it is during the pendency of this thing has been done, we should have amended the writ petition and brought it to the notice of the learned single judge because that has not been dealt with by the learned single judge.
My lord, that has not been dealt with.
Then,
but your lordship.
Obviously, to be considered.
My lord, to be considered. But your lordship kindly see page 38.
38 of?
My lord, 38 of the running page. That's the writ of your lord.
Writ petition. Which document? RTI?
Well, that is RTI, your lordship. That is not RTI, they have intimated, that is, government has intimated, your lordship.
With reference to your grievance petition for appointment of RS scheme, the government after careful
Even
consideration has
like
been plead not to consider this.
Mohammed Rizwan
Not to
to
consider.
be considered.
My lord, there are.
अरे भाई काई ये where is that document that he is has been given appointment?
No, Shakil application was not considered.
No, he is relying on that very particular. He is making out a case that Mohammed Rizwan, person who was. So where is that document? If your entire case is based on that, where is that? Have you taken any ground in the writ appeal also?
My lord, I have taken it down.
Where is that?
That is your
Which
lordship.
paragraph? See,
My lord. Problem is, your lordship frankly admit that.
देखी ना दी यदि prepare हो दो.
My lord, kindly have a glance to running page 37. Running page 37. Information on application dated 16/4/2011, MD Rizwan under RTI Act. The proposal for appointment of applicants under rehabilitation assistance scheme on disability ground of the father are not being considered by government. Rizwan रे मध्य consider ही नहीं.
Verified minutely, we want that particular document.
My lord.
Grounds taken in the writ appeal or not, any document annexed to the writ appeal or not, and what is the reply given by the other side to that particular averment or that particular document.
ये J ground J.
My lord.
7 ground J देखो.
For that, it is a clear case of discrimination where documents clearly says that the application of two candidates was rejected. One is MD Shakil and another is Abhay. Sheriff and MD Shakil approached the Honorable Court challenging the said order where his name finds place in the Annex 12 of the writ petition. This Honorable Court remanded it to the government and accordingly the government has given appointment overnight and MD circuit, but in the case of petitioner, the learned single judge has rejected the claim when the retirement is given to the employee on invalidation ground with same term and condition.
What is your stand against this particular ground? J.
Counter तो हमारा स्टेट फाइल है
Counter file is right.
problem आ गया ये lot
गवर्नमेंट
ये लिखा है जी अंडर सेक्रेटरी opposite party number 1 writ appeal file is ना opposite party number 1
file नहीं
government in online. You have already filed your counter affidavit, which is at flag B. It is not there, so get it in your pen drive, collect it and see that.
Filed under secretary, water resources department has filed it. What is see?
My lord. Next week, my lord.
The two similarly situated persons, case was also rejected by you. They challenged in the before.
Subsequently, it was considered.
And the on the direction of the single judge, their case was considered.
Yes.
That is his case. But it was not argued before. Not taken. How the learned single judge will know?
No, single judge को मैं जानूँगा. To be considered. एठी भी वर्तमान आपण जो नहुचंदी, तारो we want to see that what stand at least.
No stand is there.
So now the scheme the representative was elected from promoted regarding the
reply to that, Paraji, you have not said anything.
Have you got the copy with you now, Mr. Naik?
नहीं जी, पसंद नहीं थी मैंने
ପାରାବାଇ କମେଣ୍ଟ ତାଙ୍କର ଏଇ ଯୋଉ ଗ୍ରାଉଣ୍ଡ ଟା ନେଇଛନ୍ତି ନା ପିଲେ ସେଥିପାଇଁ ଆପଣ କାଉଣ୍ଟରରେ କଣ ଲେଖିଛନ୍ତି ଦେଖନ୍ତୁ. All right, during course of argument, अच्छा ଲେଖନ୍ତୁ, this writ appeal has been filed by the appellant Mohammad Rizwan, challenge order dated 24/2011. Now, court board challenging the order dated 14/1/2020. 14/1/2020 passed by the land single judge of this court in WPC number 10394 of 2013, wherein the prayer made by the appellant for appointment rehabilitation assistance scheme was dismissed, was not entertained.
In the counter, they have not taken that, not answer.
Just a minute. In the writ appeal, in ground number J, it is stated as follows. Quote to ground number J in entirety. No document in support of the averment in the ground has been annexed to the writ appeal. Stop. Counter affidavit has already been filed by the opposite party number 1. And
they have dealt with.
In paragraph 4, this aspect has been dealt with. However, the Learned Counsel for the state submits that the counter affidavit is not available in file, and he may be permitted to take the counter affidavit in his pen drive. Land Council for the state is permitted to take the counter affidavit, this pen drive, put up this matter on give a date and, no.
Your para J, ground para J has already been replied in para 4 of the counter, just see.
But technically, on another ground, why will not single?
Whatever,
That
that's the
is
ground.
post fact approval, post fact approval. That is the point, you know.
Out of date, not fast approval.
I'm appealing for the opposite, but 2 to 5.
The Land Council so also appears for the opposite party number 225. Opposite party knows the respondents number for this. It are for the Mr. Sanjeev Mahanti, Land Council appearing for the appellant, Mr. Naik for the opposite state, and so on so for opposite party respondents number. Keve, kete to get 225. You have received the copy of the counter affidavit. You'll have to face up, please.
Quick list, item number 1.
Undertaken signatory of IBC, punishment like imprisonment and to pay fine of 10,000 committed of the offence under section 2 IPC in defense of payment of fine to undergo RI Patim. IN number 2092-2025 for sterilization.
Call for the trial court report. Interim application for bail and sterilization of fine to be considered after receipt of the trial court report. Deposition copy to be supplied to the Land Council for the state in the meantime.
Item 2.
Land contractor number 302 and 20 for a period of line final and
All right.
Item number 3.
Yeah.
Two years, 4 months. 2 years, 4 months. 902 दिन total.
But he has mentioned that he's in good custody for more than 9 years.
Copy thanks.
No.
Why Ravi Kumar? Yes. $902 days. As on 17/7/2025.
What is name? Why Ravi Kumar?
ବେଲେ ଯାଇଛି ନା 14/5/16 ଆରେଷ୍ଟ ହେଲା 2/11/18 ରିଲିଜ।
After conviction? Thirty-six, 2022.
Period of undergoing that convict ସେ clause ସେଥିରେ କିଛି ଲେଖା ହେଇନି।
He was available on that day or not?
Judgment at the
Come to the last paragraph. Yes, he was there. So if it is for 902 days, then after conviction, it is on 36/2022. So it becomes 3 years and about a month or so. So 3 years, 1 month and it upon kete hisab kortile?
902 days.
Huh?
902 days meant 2 years, 4 months.
2 years, 4 months and then 3 years, 1 month. So it becomes 5 years, 5 months. Whether your bail application was earlier rejected?
6/12/2020.
6/12/2020.
Let's wait for some time now.
It is not complete.
ଲେଖି ନାହାନ୍ତି ଟୋଟାଲ ସେ କନଭିକ୍ସନ
ଏଇଟା ଆପଣଙ୍କର period undergone as a convict should have
B.
been mentioned here.
B ଟା fill up in.
Should have been filled up. We do not know that maybe he is not Special Jail Jaipur after conviction. He might have gone to some other.
Yes.
That may be the reason.
My instruction is throughout to trial he was inside custody.
No.
At present, he is in which jail?
Boklatma Koraput. And this is Jaipur. Boklatma is from Koraput. Koraput.
I'll put record as Shiva. Mr. Naik,
My lord.
this information is not correct. Come to the order sheet.
Yes, my lord. Date of release on bail in custody. It is mentioned. Date of release in custody.
Who has furnished it?
The
He has to file
superintendent special.
He has submitted a false report.
My lord.
Completely wrong report. Look on it. The London Council for the state has produced was asked to produce the custody certificate as per the order dated 7/7/2025. Today, the Land Council state has produced the custody certificate from Superintendent Special J. Jaipur, dated 17/7/2025, which indicates that the petitioner was admitted in jail on 14/5/2016 and he was released from jail on 2/11/2018. As such, the total period in se period भी थिला ना se period of bail in total. He was not in bail. The order sheet I have seen.
But he is now in Koraput circle jail.
Maybe, but
After conviction.
let him explain. So, कौन लिख लें? Is for 902 days. The period undergone as convict has been done. From the impugned judgment, we find from the heading of accused details that the appellant was arrested on 15/5/2016. However, under the heading of date of release on bail, it is mentioned as inverted comma vitere in custody. We have also verified from the order sheet of the London trial court, which shows that the appellant was never released on bail during trial. And he was all along produced from the jail custody of Circle Jail Koraput. Therefore, the statement made by the superintendent in the custody certificate that he was released on 2/11/2018 is not correct. In view of such submission made by the Land Council for the Land Council for the appellant submits that he has instruction that the petitioner was never released on bail after he was taken into judicial custody for the first time on such and such day. 15/14/5 till date. In view of such submission made by the Land Council for the appellants, also the Land Council for the state, let an affidavit, and on verification of the record, we feel it proper that the jail superintendent, Special Jail Jaipur, shall file an affidavit as to why he has submitted a false report before this court and why appropriate action of Courts Act shall not be initiated against him. A free copy of the order be handed over to the Land Council for the state matter will be listed in the week commencing from 1 September 2025. Yes.
Item number 4.
No. That's all. What happened with this one? And the
appellant is in custody since 30 May 2020 and 2018. He responded that it's a case where matter rising out of a collision of the petitioner was riding a Dala auto, and the deceased was coming in and prior to the accident, there was a occurrence, there was a hot exchange of word between the younger brother of the appellant and the deceased. So on the date of occurrence, it's a case that both collided with the vehicle and his vehicle and motorcycle. But thereafter, the deceased got taken by to the hospital, then shifted to hospital, SC Medical College, when he died. Thereafter, on the next day, FIR was lodged. But case was developed by two witnesses that collusion part is there, that there is an accident that is there. Two witnesses developed that he assaulted by means of also by used a sharp cutting weapon. That they are also completely overruled by the doctor And during trial also, neither the IO seized any weapon of offense, nothing.
The prosecution case is that this appellant assaulted by means of a bhujali to the deceased, for which he died. That's the background of the case. But why you say that it is not supported by the medical evidence?
My submission in twofold. First of all, prosecution said that witnesses said that he assaulted Bhujali, then he fled away. Neither the Bhujali has been seized during entire.
The eyewitnesses are there.
Two witnesses, but I am coming, my lord.
Who are the eyewitnesses?
5 and my lord, your lordship.
6 and 7.
6 and 7 are the eyewitnesses.
6 and 7, 2 eyewitnesses.
And who is the doctor who conducted PA?
25. Your lordship, my lord. 25 years, your lordship will see. And the injury sustained, all are mallet. This is sustained mallet, stitch wound, lacerated wound, and panel mallet. Paragraph 3. Doctor opined that the above mentioned external injuries and their internal effects were antemortem in nature and were caused by hard and blunt force impact. And entire during investigation also, neither weapon of offense was seized by the police.
And lastly, I found the manner of death was homicidal on the basis of the above finding.
Nothing has been discussed regarding weapon of offense except the oral testimony of the victim, eyewitness to eyewitness. And a scientific officer who went to the spot has also, scientific officer who is 26 mallet, he had also went and given a report that there is a vehicles collided with each other. So he is found that is mallet comes. So it has also.
Who is the informant in this case?
Father of the deceased who lost the fire after hearing alert.
PW2.
He is not an PW2. He is not an eyewitness to the occurrence.
But 6 and 7 are.
6 and 7 are eyewitness to the occurrence, and oral dying declaration is also there. PW9. Oral dying PW5. And PW9, he stated that soon before the occurrence, there was a quarrel between the accused and the deceased. Eyewitnesses have stated that first collusion between two vehicles, thereafter the accused brought one Bhujali and assaulted. And injury, which are Dr. PW25, the corresponding injuries are also there, and the finding of the doctor, the cause of death is due to homicidal nature.
How do you say, Mr. Naik? The doctor has stated that he has lacerated wounds, and it is caused by the hard and blunt force impact.
Yes.
So obviously this Bhujali is not a hard and blunt weapon. So you have not explained that how the injuries were possible.
Finally, doctor opined that
homicidal death nobody disputes it.
Yes,
but let us say your eyewitnesses have stated that the bhujali is the weapon of offense.
Yes, my
And
lord. PW
bhujali, where the blows were inflicted by means of on the different parts of the body like face, chest, right leg, all these parts.
Yes.
So how do you, that bhujali was not produced in
Yes.
during trial. He submits that.
Nothing sealed. It is also not sealed.
And your doctor has stated that these are all lacerated wounds. Who is that PM doctor dying declaration?
Oral dying declaration before PW 5.
ଭାଇ ତା ଭାଇ କହୁଛି ମୁଁ ହସ୍ପିଟାଲରେ ଯାଇକି ପଚାରିଲି ମୋ ଭାଇ କହିଲା ଯେ ହଁ ମତେ
I went near him. On being asked, my brother told me that accused came with his auto and dashed my motorcycle. And when I fell down, the accused dealt bhujali blow to him on his right side, face, chest, starting from neck and right leg above heel. As his condition was serious.
he went to the hospital. 25 in para 5 of the cross examination. Para 5, 25. We do 25 para 5. Some of the injuries might be
Accidental, but not combination of injury found in this case.
It is a fact that if there is a assault by a sharp cutting weapon, by its sharp side, incise and cut injuries are possible.
So is it not a case where the oral testimony contradicts the medical one? Your doctor has not stated so that it is these are injuries can be possible by bhujali also. He states about the hard and blunt impact, and further stated in the cross examination that if the sharp cutting weapon are used, then ordinarily that incised wound or cut injuries are possible, which was not noticed in the person of the deceased. You are in custody since 2018.
2018.
Are the London Council for the Council for the State. The London Council for the petitioner submits that the petition is in judicial custody since 30/5/2018. There are two eyewitnesses to the occurrence, that is PW 6 and 7, who have stated that after there was a dashing between the motorcycles of the deceased and the appellant. The appellant assaulted the deceased by means of a bhujali on different parts of the body. And similar is the oral dying declaration which is made before PW5, the brother of the deceased. However, the doctor who conducted post-mortem examination, Dr. PW25, who conducted post-mortem examination, has noticed lacerated wounds on different parts of the deceased and opined that those injuries were antemortem in nature and caused by hard and blunt force impact. If further stated in the cross-examination that if any assault is made by a sharp cutting weapon by sharp side, then incised and cut injuries are possible. Mr. Jafulal and counsel submits that neither the bhujali, the weapon of alleged weapon of offense, was produced in nor any clarification was sought for from the doctor at post-mortem examination to correlate the ocular testimony with the medical evidence. And in a case of this nature, where the medical evidence runs contrary to the oral evidence, there are good chances of success of the appellant in the appeal, and balance of convenience is in his favor. And there is no likelihood of the appeal being taken up in near future for hearing. Therefore, the bail will be favorably considered. Stop. Learned counsel for the state oppose the prayer for bail, where the statements of the two eyewitnesses, the witness to the dying declaration, so also the evidence of the doctor PW 25. Considering the submission made by the land counsel for the respective parties, the nature of evidence adduced during trial, the contradictions between the oral evidence and medical evidence as pointed out by the counsel for the appellant, period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail, allowed stay relation of fine.
Item 5.
At 5, but on behalf of the parents, now kindly praying for an action.
Kindly,
Praying for action and
when you want it, ma'am. If chahuchundi,
next.
1st of September 2025.
Item 6.
So, appellant have been appellant for in custody since 15/11/2015. And you are moving the second item.
I have the second item. I am moving for the first item.
Okay. How many years you are in custody, Mr. Sahu?
15/11/2015.
15/11?
2015.
Custody certificate is available?
No, my lord, judgment it was.
Judgment it is mentioned.
Yes, my lord. 2015.
Okay, so both of them are in custody since 25/12/2015. So it is 9 years and
Near about 10 years.
10 years control. 9 years completed. 9 years, 8 months.
8
Okay. How many times your bail application was earlier rejected?
My bail application was never rejected.
My bail application also never rejected. This first time.
Okay. Is it a case of direct evidence or
Circumstantial evidence.
what is the name of the deceased?
There are two deceased. Two couples, doctors were murdered by.
It's a case of docket with murder.
Yes.
Dr. Prafulla Kumar Mishra and his wife Susana. So it is that Silas Bihar case, okay?
Yes, madam.
What about the criminal antecedent?
Get it.
The land counsel for the state seeks some time to obtain instruction regarding the criminal antecedent. Also the conduct of the petitioner inside the jail and custody certificate. Put of this matter after Durga Puja holiday.
Item 7.
And hold on. Hope Mr. Soganda kindly be on deck and pass on this net.
Pass over you want?
Yes, yes.
Item 8.
Yeah.
Item 8.
Item 8, my lord, deposition copy not served. Please serve. Deposition copy.
Land counsel for the state submits that he has not the deposition copy. Land counsel for the apply submit that you will supply the deposition copies to the land council for the state during course of this week. Out of this matter, we commencing from 1st September. Yes.
Can I claim it? Can I take the top copy of the deposition?
Mr. Panda, land council appearing for in CRLA number 1353 of 24 submits that since the soft copy of the trial court record has been received, he may be permitted to take the copies of deposition in his pen drive. Registry shall allow Mr. Panda to take the deposition copy in his pen drive. This is as 1353 of 24. I wait a list of along with so on so. Yes, next.
Item 9.
That was extensively hard by your proxy. Earlier. 14/7. On 14/7. So, I have given a note now.
Yes, Mr. Mohanty.
I have also submitted the note. The refresh note. PW 1 to 6 are supposed to be the eyewitness. None of them has stated that I was present in this spot.
You are moving in which one?
Gati Kushta, only Gati Kushta.
Acha, just in there. CR 31. 2025. Sole appellant there.
All witnesses have said Gati Babu କହିଛନ୍ତି ମାନ
Paragraph 14 will also.
witnesses କହିଛନ୍ତି Gati Babu କହିଛି ମାନ ମୁଁ ଅଛି Gati Babu କହିଛି
Paragraph 14 to 17.
Not stated about your presence, but stated that Gati Babu କହିଛନ୍ତି ମାର ଇଏ ତ?
Yes. I
remember.
Who are those witnesses who have stated Gati Babu କହିଛନ୍ତି? Eyewitness ମାନେ ହେଲେ PW 6. Who are those two witnesses who stated?
PW.
এই ଯୋଉ ଗତି ବାବୁ କହିଛନ୍ତି ମାର ବୋଲି
ଏଟା PW1 ବି କହିଛି PW1 କହିଛି while the accused persons were asserting the deceit were uttering that ଶଳାକୁ ମାରିଦିଅ ଗତି ବାବୁ ଅଛନ୍ତି ଆମର କିଏ କିଛି କରିପାରିବେ another ଗତି ବାବୁଙ୍କ କଥାରେ ଯିଏ ନ ଯିବ ତାକୁ ଏଇଆ କରି ଏମିତି କହିଥିଲା ଆମେ ସେମିତି କଲୁ ତାକୁ ଜୀବନରେ ମାରି ସଫା କରିଦେଲୁ. This is PW1 himself. Then PW2 doesn't speak anything. PW3 will state
PW2 କହିଛି PW3 paragraph 3 ରେ
PW2
ମଧ୍ୟ କହିଛି paragraph 3
my lord କହିଛନ୍ତି
ଶଳାକୁ ଜୀବନରେ ମାରିଦିଅ ଗତି ସ୍ୱାଇଁ କହିଛି ମୁଁ ସବୁ ଖର୍ଚ୍ଚ ବୁଝିବି. Then my lord
PW3 also stated at paragraph 3.
Same statement. ଶଳାକୁ ଜୀବନରେ ମାରିଦିଅ ଗତି ସ୍ୱାଇଁ ମୁଁ ସବୁ ଖର୍ଚ୍ଚ ବୁଝିବି.
That is how we asked last time. whether he's taking care of you, Goti Babu is taking care of you or not. That's what we asked.
He has engaged a senior advocate, what kind of?
Then PW4 says about the conspiracy.
PW4. ନାଇଁ PW4 ମଧ୍ୟ କହୁଛି ନା
Is eyewitness to the occurrence as well as conspiracy to the
Castle to Nanda, Govinda Vera at the time accused Prashant Aqua was saying, Aku Mari Safa Kardio, Amon Neta କହିଛନ୍ତି ସବୁ ଖର୍ଚ୍ଚ ବହନ କରିବେ। PW5 it's about the conspiracy. W6 କହିଛି 4-5 ଦିଟା ଯାକ conspiracy. PW6 କହିଛି at that time accused Padya Swami was saying ମୋ ଦାଦା ଗତିକୃଷ୍ଣ ସ୍ୱାଇଁ କହିଛନ୍ତି ୟାକୁ ମାରିକି ଶେଷ କରିଦିଅ, ସେ ସବୁ ଖର୍ଚ୍ଚ ବହନ କରିବ। The conspiracy, let's can you see 4 and 5? Let's see, can they have a glance? Four was on 21/10/2020 at about 10 p.m. As your let's see, got it. Paragraph 3. I, along with Bharat Behra, were going in front of our village. On the way, I found all the accused were gathered near Ramliran. There was a meeting between them under the leadership of accused Dr. and I heard from them that they have planned to attack on the house of informant Sunita Katra. Then, Lord, Ramlila ground, se Uptundi Vasiki Ram Mandira Ajere Mandapre. Conspiracy करते हैं टाइमिंग टा देखो तो गोटे ये कला 10 p.m. PW6 कहला PW5 6:30 about 2 years back, paragraph 2. At about 2 years back, one day on 21st during the month of Dasara, at about 6:30 p.m., while I was going to the informant Sunita Katra on the way, I find all Ramlila Ghara near the house of accused Gotai, and they were organizing meetings. Since I told my Nanda.
Punishment is same, Mr. Mahanti. Abatement.
That I understand. Then my lord, your lordship may kindly have a glance at the evidence of IO. There are two IOs, you know. One is 14, another is 14.
You are in custody since when?
From the date of judgment.
Prior to that, you are on bail.
I was on bail. Guru Dimas Konde Rohila for a bail.
This report has come against you that you are an influential political leader in the local. And Supporters of are creating havoc in the locality, threatening the family members of the deceased, prosecution.
For last 4 years,
Yeah.
I have not done anything. While I was outside.
Mr. Naik, you are saying that his conduct during the bail period, such and such, is not good means what?
There subsequently another affair is also
Not
registered.
good means you have to tell whether any case is registered. Merely means what?
The case you say, of course, he mentioned it that in that case, perhaps charge sheet has been submitted, but
Yes.
what is the offense after all?
It's in my note. We have submitted already, that charge sheet has been submitted.
No, that we have also recorded it.
Note ନାହିଁ note ପଛରେ ଆମେ ଦେଇଛୁ ସେଥିରେ note ରେ ଖାଲି ଦେଇଛୁ
251 ଆଉ ଗୋଟେ କେସ୍ ଅଛି ସେ ନୋଟ ରିପୋର୍ଟରେ ଦେଇଛୁ।
that is prior to the incident ନା
yes
ସେଇଟା କୁହ ଆଉ ଅଛି
କାହିଁ ସେ ନୋଟଟା କାହିଁ?
ନା ଆମ note ରେ ନାହିଁ ସେ କଥାଟା charge sheet
ନାହିଁ।
କିନ୍ତୁ ଆମେ submission କରିଥିଲୁ charge sheet ହେଇଛି।
So what do you say, Mike?
My lord.
He was on bail during trial.
Yes.
And admittedly, your own witnesses have stated that he was not present at the scene of occurrence. Question is of abatement.
Yes, he is not present at the scene of the occurrence, but he is the mastermind. On his behest, the occurrence was took place.
Ultimately,
And previously, before the date of occurrence, there was also one attempt, one planning, and in that respect, stationary entry was also made. IO.
Our contention, your lordship, is
that
admissibility,
admissibility
and the finding. Stationary entry ହେଲା ये entry कला से examine होला stationary ର extract ଆସିଲା examine ହେଲା attested copy ଯିଏ କଲା ସେ ବି evidence ହେଲା
how far it is believable that somebody, suppose he is a mastermind behind the crime, he is keeping himself away, and he will be such a fool that he will tell others that go and mention my name at this spot. That I have instructed
the accused person, those who have committed the offense, they have stated that.
Is it possible? Is it acceptable? That if some planning is made and he is remaining away from the spot, not coming to the place, and he will tell others, at least he will be careful enough to say that don't disclose my name. That would be the first thing he used to do.
But
how he will instruct others that tell in the spot that I am.
He has not instructed.
He would have come to the spot to commit the crime.
He has not instructed, but PW4 and 5.
Your witness have stated that the accused person stated like.
They have stated, yes.
So once a person like him, who is such an influential person, sends these persons to execute the crime, you will be extremely careful enough to say that don't disclose my name. Just go and commit the offense, come away.
The eyewitness statement, along with the statement of PW4 and 5, witness to the conspiracy, and the stationary entry made on 17 before the occurrence. That is,
all these things are to be, we are not going to that. It is to be appreciated at the time of final hearing. But we are not just for the purpose of bail. The man who was on bail, no doubt, and you have stated that he has his conduct was not good, but you are not producing any material that how he has misutilized the liberty. Is there any complaint during course of trial before the trial court that such and such thing has been committed by the accused?
Only the witnesses. The inspector has wrote this letter.
What is the basis of writing not good?
There must be some
sufficient. We are not asking his opinion. We are asking his the material.
आपनकर जणे कंडक्ट गुड न हला माने आइदर स्टेशनरी एंट्री थिबो नचेत किछि रिपोर्ट हेतिबो जदी ओवरटाइट कला नचेत एटलीस्ट बिफोर द ट्रायल कोर्ट कंप्लेन हेतिबो जे आगे एमती धमका धमकी करूचंदी କିଛି ଯଦି ନଥିବ ଇଏ ଗୋଟେ ରିପୋର୍ଟ ଦେଇଦେଇଛି not good ଆଚ୍ଛା tomorrow suppose he flouts any condition you can very well file an application for cancellation of bail also. You are not if anything he intends to deviate from the terms and
That can be.
that can be done. So why a person who is not the direct participant and who according to you has abated and ultimately it is to be seen that how that abatement part whether it is acceptable or not at the final stage of hearing. So yes, Mr. Robert, what do you say?
In this case, my lord, what happened, my lord? We do one, my lord. Stated in the evidence in chief, my lord, paragraph 2. One day, accused Gatikshwar Swai came to our house and threatened my house informant to kill my brother Nanda and Govinda Behera, as my brother did not act as per his instruction of accused Gatikshwar Swai. But likewise, other witnesses stated that, my lord. Prior to the occurrence, my lord, he threatened for that is in a session that made, my lord. Subsequently, my lord, a conspiracy there, my lord, prior to the occurrence, my lord, that has been, my lord, witnessed by a police officer, my lord. We told 14 specifically stated that Unit 35, my lord.
Conspiracy will be made in an open place, which will be audible to others and they will come and declare.
My instruction, my lord, Gatikshwar Swai, such a person that locality, my lord, nobody dare to speak anything wrong, my lord. His political career, he was chairman of that, my lord, locality. Everybody afraid of him. Today also the father of the deceased came to me, my lord. He stated that he is under apprehension. The moment he will release on bail, my lord, then definitely another person will.
That is the instruction. Taken judicial notice of.
That is the instruction, apprehension.
जे सकाळे आसी सेवा से आसी रगड़ हमको जे आज्ञा बेल हे गले मते मारी देबे एगुडा जुडिशियल नोटिस ने जो
We are not taking out. We are not filing any affidavit or filing out. This man was on bail during trial. So, is there any material?
For that manner, nobody dare to lodge in reports against him, my lord. But since, my lord, the house of the informant, my lord, in this case, my lord, we don't want to stated that prior to occurrence, they threatened the.
So, in spite of all such thing, is a powerful man was outside, but all your witnesses consistently deposed against him. So that shows that there was no impact of his release on the witnesses.
He has not influenced the witnesses. So that's the reason they are loudly saying his name.
My lord, paper book is ready, my lord.
And
yes,
my lord,
in this case,
if he was so influential, he could have influenced all.
Police protection also provided to the wife of deceased, my lord. Prior to the incident, when he threatened, prior to occurrence, police protection given. In spite of police protection, my lord, this case.
What is the materials?
And that is there, my lord. The period 14 second, my lord. I'm judging of my lord.
We are granting him interim bail. We will see
his conduct. Interim bail.
Let us see that. Look on Hard the Land and Council. Mr. Ashok Council and Senior Advocate for the petitioner and counsel for the state. Mr. Mahanti submits that the eyewitnesses have not spoken about the presence of the petitioner at the scene. However, they have stated that the other accused persons who directly participated in the assault of the deceased stated that they were the petitioner abated them to commit the crime. He was on bail, he was on bail and there is no allegation of misutilization of liberty. Further submits that after the pronouncement of the judgment, the on 8/11/2024, the petitioner has been taken into judicial custody. And the abatement part is a doubt, and therefore, since there are no chances of early hearing of the appeal, as it is the appeal of the year 2025, the bail application may be favorably considered. The London Council for the state has produced a report from the IIC Banki Police Station dated 15/7/2025, which shows that the conduct of the appellant while he was on bail from 24/12/2020 to 7/11/2024 was not good. However, the Land Council for the state fairly submits that no such report against the conduct of the appellant has been lodged during the period in question. However, we find also that even though the appellant was on bail, but the eyewitnesses supported the prosecution case and also named the appellant as the abettor of the crime. Stop. The Land Council submits that there is threat to the family members of the deceased and the prosecution witnesses in case the petitioner is released on bail, which would be evident from the report submitted by the IIC Banki Police Station. Considering the submission made by the Land Council for the respective parties, since the petitioner was on bail during trial and there is no allegation of misutilization of liberty, at this juncture, we are inclined to release the petitioner on bail for a period of 3 months. While on bail, the petitioner shall not try to come in contact with any of the family members of the deceased or the prosecution witnesses and shall not commit involved in any criminal activities. The inspector in charge of Banki Police Station shall keep a close watch on the activities of the petitioner while on bail, and the petitioner shall report once in a week on every Sunday in the police station and in between 10 a.m. to 4 p.m. And violation of condition shall entail cancellation of bail. Mr. Robert, the Land Council, Land Council for the informant also opposed the prayer for bail. The report submitted by the Land Council for the state is taken on record. Free copy of the order be handed over to the Land Council for the state, which will be communicated to the IIC of the concerned police station. Yes.
Third sub-item, madam.
CRLA 430 of 2025 is a double filing.
Which one?
CRL
430 कौन है जी?
Sir, double filing. Criminal appeal number 50 of 2025 रे accused number 5.
So one is to be no एटा कौन दी जन जाको गोटे appellant अछि ना कौन?
हाँ गोटे माने accused number 5 in CRLA 50 of 2025 and the criminal appeal number
430 ताले withdraw कर देवे जो.
There is a prisoner's petition.
No, once you are an appellant in that case, how a subsequent criminal appeal is maintainable? You have already filed a criminal appeal, number 50 of, so during pendency of that criminal appeal, a regular appeal, it's not a appeal, how you can file another, and you have mentioned that what has never before this court, that is also a wrong certificate has been given. No, it's all right, you are not aware. So you should better withdraw it, not press it. Subsequently, you can, in that case, suppose the instruction comes that you can file the prisoner's petition that so far as 50 of 2025 is concerned, my case will be conducted by X, Mr. X. So you can argue in that criminal appeal for that particular appellant. But how if another criminal appeal will be maintainable during pendency of this? Right? Let's on to Miss A. Mehta, Land Council, the appellant in CRL number 430 of 25 submits that since the appellant has already filed another criminal appeal, that is 50 of 2025, in which she is appellant number 5, she does not want to press this criminal appeal. Accordingly, CRL is disposed of as not pressed. Yes. Direct excellent though. That will come after Durga Puja holidays. You will see the man and then
May be permitted to place for the bail of The present appellant, my lords.
You cannot, because you have no power in that case.
My
That prisoner's petition has to come, and you are to enter appearance for that in the first criminal appeal. 50, then you'll be permitted to file a separate bail application, and then you can move it. Okay, yes, next.
my lords, in item 10.
Yes, item 10.
And the last
Item 10.
by the order dated 1/8/2025, my lords was pleased to call for the criminal antecedent.
Yes, Mr. Nair. কেতে পিরিয়ড হয়েছে? हाँ, 2 वर्ष 8 मास. What is the case?
It's a case of uxorious site, my lords. There is no eyewitness to the present occurrence. The case rests on circumstantial evidence, my lords.
What are the circumstances?
My lords, it is the case of the prosecution that the PW5 is one of the deceased as well as the appellant. He was the informant and he has registered the FIR, but he has turned hostile, my lord, subsequently.
What is the name of the deceased?
Name of the deceased is Nirmala, my lords.
Nirmala.
Nirmala Sahoo,
Lady.
my lords. The appellant has killed his wife, my lords.
What is the date of occurrence?
Date of occurrence, my lords, 18/3/2017.
So the circumstances have been jotted down anywhere in the judgment that these are the circumstances.
Now let's return to
By the way, what are the circumstances according to the London trial? Last scene is there?
yes, my lords. Last scene.
Who has stated about last scene?
My lords, that is the my lords, it is because the cases with regard to
No, you come to paragraph number 8.
my lord.
It is mentioned that the entire case is based on circumstantial evidence, that is last seen together.
Am I permitted to place?
पढ़ो तो सुनो.
The entire case is based on circumstantial evidence, that is the last seen theory. No one has seen the person who committed murder of the deceased, but circumstance will speak so if proved. In the instant case, the prosecution has examined the doctor who has conducted autopsy over the dead body of the deceased as PW7. As such, in his statement, will be paramount to arrive at the conclusion that the death of the deceased was nothing but homicidal one. Though the contents of the FIR under EXC 10 infers about the fact of murder being committed by the accused, accompanied by the attending circumstances, the conduct of
So it is asphyxia by manual throttling. So that is the report. Then you are homicidal one. So leave it. So that is not disputed. Now we come to the, what are the circumstances? Okay, you come to paragraph number 9. And the prosecution case is that the accused husband committed oxide on suspicion of infidelity of the deceased, whereas the defense case not so. So the deceased was your wife,
my lord.
or you are staying together,
My lord.
and the case is of strangulation.
Yes.
What is your explanation? How your wife died?
My lords, my lords, I was not present, my lords, as well as the fact that I have, it has been stated that I have confessed before Lingaraj police station, my lords, and that I have committed the said murder, and with regard to that, an SD entry has been made. That has been thereafter seized as the investigation was carried out by Dholi police station.
No, you come to paragraph number 12, where all these circumstances have been jotted down. First of all, you are suspecting the character of the deceased, right? Number 1. Number 2, it's a homicidal death, and you came to Lingaraj police station, reported about to have committed the murder of the deceased. Number 3, basing on your confession, a station diary entry was made. Police came to your house where you were residing together with the deceased, and you opened the door of that house.
Yes, ma'am.
And the dead body was found there.
Inside the house.
And then so now, what is your explanation? You came up during course of investigation that you also swallowed poison to kill yourself after
Yes,
killing the wife.
Wait.
Yes, ma'am.
Obviously, you have not explained anything about how do you discharge your burden under section 106 of the Evidence Act. So you were in the company of your wife, and wife met homicidal death, case of strangulation. You went to the police station, lost a report, station diary entry was made. Police officials came, you opened the house, the dead body was there inside. It was a homicidal death which was confirmed after conducting PM. And these are the things. Some material are there that you are suspecting the character of your wife.
Madam,
So
there is no evidence with regard to who has, no independent witnesses were examined during the trial. Not the neighbors, no any
where
person
from
living
the
in the
independent witness come? It happened all in the
No, it's because there is no material available.
inside your house, inside the four walls of your house.
There is no material available on record to even establish that they were seen together inside the house, madam.
No, it is not X, Y, or Z's house. Is it your case that the house from which the dead body was found, it was not in your, not your house?
It is a rented house where the appellant, the deceased, and their two sons, that is PW 4 and 5, were living together, madam.
Is this matter after Durga Puja holiday? Yes, next.
Item 11.
I was in custody then. 120B, that is the allegation against me. So I stand in a different, and the evidence is also different. Allegation is when the informant and the deceased, they are having been from when he tried to escape, again the chase taken, not walk, that is the homicide. Was 9:15 at our witnesses. So far as conspiracy is concerned, PW 3 and 7.
1, 9, and 15.
Are the eyewitnesses.
What role has been attributed to you? One and
3 and 7, 3 and 7, so far I am concerned. Allegation is, I was taken in the escort van to the port because I was on my way. In that van, I discussed with along other 5 persons relating to the conflict that I am going to commit the murder. And 2 persons who are having different near that stall nearby, they could hear it. They never disclosed before anybody. 1 month after, suddenly police came to know that they are the witnesses who heard about the conspiracy.
So, no, is it the submission which you are making that PW 1, 9, and 15 are they are the eyewitnesses to the occurrence? Is it correct that they are the only eyewitnesses?
Yes, yes.
Okay. What is the name of the deceased?
Kanti Mishra.
Kanti Mishra. When the occurrence took place?
That was on 29/1/13.
29/1?
23.
2013.
13.
And Mr. Sarangi, your client is in jail since when?
After I was on bail. Since
After
I was
conviction.
arrested, taken on remand on 26/3/13 and released on bail on 16/7/2014.
So during trial, you were on bail.
Yes.
So this conspiracy part, which you are telling that you made it while going in a police van, that is stated by which witnesses?
3 and 7.
PW3 and PW7.
1 month after.
Let us see, they have stated in the PW, come to PW3.
Identical statement. PW3 was.
Yes, please.
I know all that is person standing in the dark, asking that for identified Toronto. I also know the information on the human line. On 24/1/13, I and Pratik Panigrai were having people in front of the canteen inside the street food campus. At that time, the expert van was parked nearby. That the accused persons, Omi Padi, Ichili Panigrai, Nago Panda, Rakesh Panda, and Satya Padi were discussing amongst themselves to murder something.
All of them were in custody.
Yeah.
All these names.
Outside. Even they have not, in which case I was produced, in which date I was produced, it's not there. As for the earlier plan, I was examined by the police in connection with this case.
By the way, you are in connection with this case, you tell 2 dates when you were taken into custody.
The present case.
In a present case.
I was taken on remand on 26/3/13.
26/3/2013. Yes. And released on bail?
On 16/7/2014. Judgment is there.
So how many cases are instituted against you?
They have given 4, I have answered them. 1 is final form, 2 I have been acquitted, 1 307 cases pending. That is all. And after 14, there is no case. Within this, there were all those during those times. During this 11 years, not a single case.
What have you brought out on this that you model your chief examination rate?
The charged witnesses. I was examined twice by the police in connection with this case. On 27/2/13, I was examined by the police in connection with this case. But I cannot recollect the second date. I cannot recollect who examined me. On that date, police personnel were present in the. We did not inform them about the discussion of the above 4 accused persons regarding the murder of Shanti Mishra. We also did not inform about this incident to the nearest police station as well as Procedural PS. Though I got information on 24/1/13 about the murder of Shanti Mishra, but I did not inform at the PS regarding the incident of 24/1/13 after his murder, that is on 29/1/13, which information I received in between 9 to 10 a.m. Many of my co-villagers accompanied Shanti Mishra to MSC Medical College Hospital, Barampur, but I had not seen any of his family members there. Actually, the family members of the members, including his brother, I also did not disclose about the incident on 24/1/13 to my co-villagers. It is not a fact that I am going to also.
So on that particular day, 24/1/2023, you are in custody in connection with some case.
Yes. That
So
is not disputed, but
they
I
are-
refuse. Neither the case number is given, neither the address is given, that in fact I was taken, nor in the code van escort police party was there, and these people do not belong to that group. And they are charged witnesses. Why not we see PW 24? 22. PW 22 person.
PW?
22.
Oui.
High bios, age wise they have done. This is the first. Paragraph 70.
I cannot say whether on 24/1/13, the accused Omni Padi, Ichiri Panigrai, Manga Panda, and Satya Padi have been produced before the court from jail custody connected in another case. There is no basis which case and whether the tipping stall exists at all or not, where the vehicle was parked, the driver or any escort party was not, there is nothing. Only these two witnesses, and they kept mom, they know the informant and the family members say this is a.
This incident took place on 29/1/2013.
Yes.
When these two witnesses gave their statement to police or the IO.
Yes, sir.
Anything brought out in the IO's evidence that when they disclosed or how the IO came to know that they are witnesses to this conspiracy or whatever it may be. So how do you say that they disclosed after 1 month?
They were examined because after one.
From which statement or what basis you are telling that? Is there anything or who was examining this PW 22?
Itself says,
No, no.
process themselves second line.
PW 24 will not should miss.
24.
Evidence in chief at paragraph 10.
Even PW3 says in para 4.
Yes.
On 27/2/2013, I was examined for para 4.
Yeah,
One month after. Para
So witness it says, I was examined after.
paragraph 4.
Para 4. Then we say,
और 12टा जोटा PW7
And also well, at the para 3. PW7 paragraph 3.
Process examination para 5 block. I was examined by the police on
27/2.
Same day. Same statement.
Para 3 stated that just at the time I overhear that Omni Padi was telling to those persons that Shanti Mishra को मारिबा पाई जेलरू योजना करिथिलु ताकू काहे की मारिनु and each person replied that within 4 to 5 days we will murder him. Thereafter we left the place after 4 to 5 days. On 29 we heard that Shanti Mishra of our area was killed by Mishra by throwing the bomb.
Same with PW 24.
There is the
Para 25.
conspiracy. The
नहीं
PW3
सी जो साक्षी जा कहउचंदी कोर्ट वैन ता हेड छिड़ाइतला आउ कोर्ट वैन रे भितरे आमी पाड़ी बसीथिला इनसाइड द कोर्ट वैन आमी पाड़ी वाज देयर एंड अन्य जो 4 जन माने से जो छिड़ाइतिले बाहर छिड़ाइतिले
Co-accused.
they are the co-accused person perhaps they were not in custody and तांको भीतर कथावार्ता होतला ये होची evidence.
And never disclosed before anybody for more than a month. So they knew the deceased and their family members.
Yes, Mr. Nayak, what do you say?
there are the 3 eyewitnesses.
Eyewitness माने obviously आंको आको ना कहिनांती the eyewitness माने अन्य को implicate करजा आंको आपनकर conspiracy रू
Conspiracy there is PW3 and 7 were detected
तीनटा
also.
evidence को believe हबो जदी ताहले कोन
केबे कले केबे प्रोड्यूस होला केबे कन्स्पिरेसी कलो व्हाट इज द डेट
Well, that second I know the informant of the case namely on 24/1/13. I was doing a color work at the Macho Market, Komapalli of the Barampur.
24.
By about 1:30 p.m. to 2 p.m. I was going to take my tiffin. Just at that time, Santosh Padi of our village was purchasing a fish, Macho Market. So I asked him, "What is it?" He replied, "Purchase a fish," and I invited him to take tiffin with me. Thereafter, I along with Santosh Padi came to the court of the Barampur to take tiffin. Just at the time, since there was a rush in the tiffin shop, So I myself and my friend were waiting near the Pindi of shop. At that place, we found that the court van was also standing, and inside the said van, Omipadi of our sitting and four other person, namely Monga Panda, Litsi Panigrai, Dr. Sahoo and Satyada Padi were just standing adjacent to the van. Just at that time, I overheard that Omipadi was telling to those persons that Mishraku ମାରିବା ପାଇଁ ଜେଲରୁ
पुलिस माने कौन करते ये ଭିତରେ ବସିଥିଲା ଏମାନେ ବାହାରେ ବସିଥିଲେ ଇଏ ଯାଇକି ଶୁଣିଲେ ଯୋଉମାନେ ଏସ୍କର୍ଟ ପାର୍ଟି ମେମ୍ବର ସେମାନେ କଣ କରୁଥିଲେ ବ୍ୟାନ୍ ଛାଡି ଦେଇ ପଳେଇଥିଲେ ଚାହା ପିଇବାକୁ
It was so thoroughfare by somebody is gone for tiffin, he is also hearing, and the other people are also participating. What kind of question it is?
Informant ପାଇଁ କିଏ ଅଛି
My learned senior Mr.
Yes, Mr. How do you say how you meet this
against him, in fact, ballot 120B ballot is not there.
Are the Land and Counsel for the petitioner, Mr. Sarangi, Mr. D.P. Dharlan, Senior Advocate for the informant, Mr. Nayak for the state, the Land Counsel for the petitioner submits. The petitioner was given on remand in connection with this case on 26/3/2013, and he was released on 15/7/2013. Though there are 3 eyewitnesses to the occurrence, that is PW 1, 9, and 15, but they have not implicated the petitioner in the assault of the deceased Santi Mishra, which is on 29/1/2014. He further submits that witnesses, namely that is PW3 and PW7, stated about the conspiracy part involving the petitioner, but they disclosed about such aspect 1 month after the alleged conspiracy, and it is very difficult to accept, to place reliance on their evidence to convict the petitioner. Further submits that there are good chances of success in the case and balance of convenience is in his favor, and therefore the bail application may be favorably considered. Stop. Land Counsel for the state has submitted that there are some criminal antecedent against the petitioner. However, Mr. Sarangi replied to such a submission that in the petitioner has been acquitted, and in one case, what happened in the one case? He was the final report was submitted on the count of mistake of fact.
Out of 5 cases, ballot in 3 cases he has been acquitted. 1 case is pending, 1 is entering finally.
Out of five cases, 2 cases he have been acquitted, 1 case final report submitted, and 1 case is subjudice. Stop. Considering the submission made by the for the respective parties, the fact that the petitioner was on bail in connection with this case during trial, and there is no material that he has misutilized his liberty in any manner while on bail, and the nature of evidence adduced during trial, absence of any chance of early hearing of the appeal in the near future. We are inclined to believe the petitioner object to condition that he shall not come in contact with the family members of the deceased or any of the prosecution witnesses, shall not indulge in any criminal activities. violation of any terms and conditions of the increased cancellation of bail. Yes, this is bail allowed. Stay violation assignment. Yes, the next one.
Because next one, criminal appeal 1203 of 24 and 1215 of 24. Both the accused, the appellants are similarly situated. Appellants, neither in
Similarly situated like Mr. Charangi's.
No.
I think.
Because here what has happened, they were first arrested on the basis of a conspiracy and with forwarded on 120B minutes. But during trial, they've been acquitted of 120B. Only with the aid of 149, they've been convicted.
No, what about the eyewitnesses?
None of the eyewitnesses stated about whispered our name. Both 9 and 15, they have not whispered either about the presence. The name is not there at all.
No, it's all right. So, eyewitnesses are not implicated.
No.
You are in trial.
During trial. No.
Just a minute. CRLA 1203 and 1215 on bail. Eyewitnesses not implicated. And so, a conspiracy part also not.
We have been acquitted.
Acha. Let us see that part particularly.
No, for document, you will also look at. Not it. Paragraph.
Ganesh and Sheikh Jafir. Yes, Ganesh. They have been acquitted. Right. 20B acquitted.
Base, you can also look at.
Now we got it.
Yes.
Then on what basis you are found guilty under this 302 by 149?
That is also the next class. If an assist come to there is no paragraph 18.
Paragraph 18.
Yes, page 52 of the internal page of the judgment. In this case, the accused persons have neither not then if an assist come. The defense pointed out some discrepancy, contradiction, but those are some minor discrepancy, contradiction available in the evidence of prosecution. So take the basic time there not. As such, the prosecution has successfully proved the charges under 147, 140, 300 to 120B against each and others. And so far as these bits of next page, Sheikh Jafar, Sheikh Babaji Rana, Ganesh Pranagiri, Tillu, Murtunja, beyond all result of 120B of they are acquitted. And thereafter no expansion, only says that 101 the accused persons. Paragraph 19.
Or
valid.
On what basis this eyewitnesses admittedly have not stated about the presence of these appellants for whom this Mr. Samantra is appearing. He has been acquitted also of the charge of conspiracy. Then on what basis this 302 by
149 is employed?
149.
On what basis? There must be something.
No discussion. It's certainly reached at a conclusion.
Just one minute.
Sorry.
Not in a hurry. So, yes, Mr. Naik. Eyewitness implicate karibeni 120B re acquittal karibe. 49 how they form the unlawful assembly and in furtherance of their common object. So what is the basis? In mechanical manner. Hard, Mr. Samantra.
My name is
hard Mr. Milan.
We thought that you
along with
No, Milan Kanu.
I will share the fees, no problem.
We'll write.
Very insistent that you appear.
This is a case of 120.
We'll write about the fees aspect in this also.
It becomes a case of 120.
Mr. Milan Kanu and senior advocate Samantra for the petitioner. It is argued on behalf of the petitioner that the petitioner has been paid during trial and there is no allegation of misutilization of liberty while on bail. It is further submitted that there are 3 eyewitnesses to the occurrence, that is PW1, PW9 and PW15, but none of them have implicated the petitioner in the commission of murder of the deceased Santi Mishra is stated to have taken place on 29/1/2013. He has also found no material about criminal conspiracy against the petitioner for which he has been acquitted of the charge under section 120B of the Indian Penal Code. However, most strangely, the London Trial Court has convicted the petitioner under section 302 by 149 of IPC along with other offences, though there are no such material on record against the petitioner that he was a member of the unlawful assembly and that the murder was committed in furtherance of the object of the unlawful, in prosecution of the common object of the unlawful assembly. He further submits that there are good chances of success in the case and knowledge of convenience is in favor of the petitioner. Therefore, the bail application may be favorably considered. Grand Counsel for the state has placed the evidence of the eyewitness. Considering the submission made by the Land Council for the respective parties, the fact that the petitioner was on bail during trial and absence of any material that he misutilized his liberty in any manner while on bail, and absence of any chance of a early hearing of the appeal in the near future. We are inclined to release the petitioner on bail. This is bail allowed in item number 1203 bail allowed, and so also 1215 also bail allowed. Allah? Order same. But both both na likhiye and Mr. D.P. Bhavan ko na likhiye, so far the counsel for the informant is concerned and Mr. Nayak for Master Counsel. Yes. Yes, next item, CRLA.
Yes, next is 1234 of 2024. Here we lost this petitioner, this applicant was also charged on the section 220B. But 120B, allegation was that he along with others, had conspired in the house of one Ramesh Janna for having to kill this deceased. But Ramesh Janna was not charged and the persons, those who were witnesses, they were declared hostile. So 120B goes not.
I not implicated.
Yes, eyewitnesses 1 and 9, they have stated about my presence on the spot, but the eyewitness PW 15 minutes in front of whose tea stall this occurrence took place. But
No. Eyewitness जो माने को ना करछन ता पछर देखिबा. Eyewitness माने जो माने को ना कहि ना दिया सुन. आउ की अछि?
Eyewitness is spelled my name is not interested.
की कितना नंबर?
That is CRL number 1356.
again,
is similar to me. That is 128.
No, you have not been implicated by the eyewitnesses.
Same 123.
Just a minute.
But he has been convicted in a case of 302 in recent past 2022.
अच्छा, ताले इता था वो चीज़.
Second tak chhad diyo. Second tak criminal antecedent किछ नहीं.
नहीं, second
पुटा शंकर बेहरा.
नहीं. ସେଇଟା ଦି ଜଣ ଅଛନ୍ତି ଗୁରୁଦାସ ଆଉ ଗୋଟେ
କେତେ ନମ୍ବର
ମାନେ
187 there are two appellants.
CRLA 1287.
Out of them, against Gurudas, he was convicted. And so far as second appellant is concerned, he has no criminal antecedent.
But he has changed Santi Mishra by holding a Bhujali in his
Shankar.
Eyewitnesses माना statement.
Shankar kata koi.
Shankar kata kuchandi.
Eyewitness is just rest.
But with regards to appellant number 2, I think no case.
Eyewitnesses माने implicate करना हंती तो.
ना.
टुकना वेरा.
नहीं.
Lekon, you are on bail during trial.
नहीं.
IA number, this is CRLA number 1287 of 24. IN number 3392 of 2024. This is an application for bail filed by the petitioners. Ms. Dipali Mahapatra, Land Counsel, appearing for the petitioner, submits that he confines the prayer in this application only for petitioner appellant number 2, Tukuna Behera, alias Gopabandhu, alias Hariom Behera, was on bail during trial, and there is no allegation of misutilization of liberty. And the eyewitnesses have also not implicated. The 3 eyewitnesses, that is PWs 1, 9, and 15, have not implicated him in the assault of the deceased Shanti Mishra, which took place on 29/1/2013. 120B and the petitioner, though faced trial on being charged under section 120B of the Indian Penal Code, but the London Trial Court has acquitted him of such charge. Further submits that there are good chances of success of the appellant, of the petitioner, and there is no chance of early hearing of the appeal in the near future, and therefore the bail application may be favorably considered. Land Counsel for the state submits that there is criminal antecedent against the petitioner Tukuna Behera. Land Counsel Mr. D.P. Dhal and senior advocate appearing for the informant also submits that there is criminal antecedent against the petitioner number 2, and the eyewitnesses have not implicated the petitioner in the crime. As per the considering the submission led by the London Council for the respective parties, the
with regards to antecedent, as per Horst affidavit, I have not ascertained that because the affidavit has been shown by
any criminal antecedent against petitioner number 2.
Tukuna Behera.
As per the sister ballot, no antecedent.
No, it is DP Dhalankar submission to no criminal antecedent. Considering the submission made by the London Council for the respective parties, fact that the petitioner was on bail during trial, absence of any material of misutilization of liberty while on bail, period of detention in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Stay relation of fine allowed. So this CRLA 1287 of 2024, Tukuna Behera, alias Gopabandhu, has been released from bail. For the other, you have to file a fresh application. Okay, next. We are not facing the application for that. We have not rejected it. Yes, next.
Can take it.
No, not a piecemeal manner. We have said it. Yes, Mr.
CRLA 1356.
Yeah.
The next time.
1356. अब बाकी तो का छुट्टी पर. Yes, 1356. Yeah. Eyewitnesses माने आपको implicate करना है Mr. Dhar?
नहीं.
अच्छा, antecedent?
Antecedent matter of mine affidavit. That of mine that so for item number 1 is concerned.
Duita?
Do number that is the
present is okay. Not
third Milord. That is
acquitted.
acquitted.
Fourth
one my lord
acquitted.
Profit amendment that offense will be 5%.
ଆଉ ଏଥିରେ ଆପଣ ବେଲ୍ ରେ ଥିଲେ?
ଆଜ୍ଞା, during my trial he was on bail from the date of the
ଆପଣଙ୍କ ଚାର୍ଜ ହେଇଥିଲା 120B ରେ?
no charge is them affidavit.
अरे चार्ज ହେଇଥିଲା କି ନାହିଁ? ପଛରେ ଆଉ ଚାର୍ଜ ହେଇଥିଲା କି ନାହିଁ? তাহলে এই যে অর্ডারটা ইয়াଙ୍କର ଡକାହେଲା ବାଜି ମହାପାତ୍ରଙ୍କର ସେଇ କେସର ଅର୍ଡର ଏଥିରେ ଲେଖିଦେବେ CRL number 1356 ବାବାଜୀ ରଣା bail granted and still relation of fine ବାକି ଯୋଉଗୁଡା ମ୍ୟାଟର ତେବେ ଆଫ୍ଟର ପୂଜା ଜଣେ କିଏ ତାମାନେ ରହିଲା ଆପଣଙ୍କର ରାକେଶ ପଣ୍ଡା ଗୋଟେ ରହିଲା ସିଏ 1, 2, 3, 4 this is after puja vacation है ना तापर 1276 of 2024 that is after puja vacation this case no eyewitnesses man आपन को ना कोई चन ना कोई ना दी
मृत्युंजय सावत
please check 1276 is all right Just one. We just want that whether any of the eyewitnesses 1-9-15 एमाने मृत्युंजय सबत्र ना कही ना आ बेल लेखिले आपण 120 भी एक्यूटल हिचंती और ताले से या टाइप कर देन the bail granted for them मृत्युंजय what about the criminal antecedent
2 criminal antecedents have been acquitted in one and other has been submitted finally.
जो ये रेखा पूर्व लिखी हो just Babaji Ronares, those different councils for the state has based on record that there are 4 against the petitioner that the land council petitioner has filed an affidavit that he has been but the leaders can जहाँ लिखा है जिस परफेक्टली academic file ତାକୁ ଦେଖିକି ଲେଖିବେ ଆଉ ଏଟା ଯୋଉ ମୃତ୍ୟୁଞ୍ଜୟ ସାବତରେ allow କରିଦେବେ ସେମିତି ସେଇ ଗ୍ରାଉଣ୍ଡ ଯୋଉଟା ଲେଖା ହେଇଛି eyewitnesses have not implicated he has been acquitted of the charge under 120B ବାକି ଯୋଉଗୁଡାକ ଅନ୍ୟ କେସରେ ଦେଖାଉନି so bail allowed and stay ପାଇଁ ତ ଫାଇନାଲ ଇଏ ନାହିଁ the bail allowed CRL number 1234 of 24-1 then CRL number 1299 of 24 is after Durga Puja holidays. Now the CRL number 1314 24 after Durga Puja holidays. Grateful. Yes, next one.
So far as 1314 is concerned,
Yeah.
your lordship call for a report on the health condition of the appellant one.
Okay, sir, ये करिए health condition report हम नहीं आती without problem. Yes, next item.
Item 12.
Well, the counsel for the informant has told me that he'll ask for an adjournment.
Next.
It will be taken up on Friday.
Friday you are available.
Friday will be. In this case, number of active persons are there. Previously, only the IA for S. Balaji Acharya moved, and I obtained the custody certificate of S. Balaji Acharya.
IA number just a minute. IA number 84 of 2025. So it has been filed for bail of for all the.
ନା ଆଗରୁ ମୁଦ୍ଦା ହୋଇଥିଲା କେବଳ ଏସ୍ ବାଲାଜୀ ଆଚାର୍ଯ୍ୟର ବର୍ତ୍ତମାନ in this case my lord there are 6 accused person. I will obtain the custody
So, Mr. Panda, you are moving for bail of all the petitioners or only?
We are moved for bail initially for this Balaji for interim bail for his sister's marriage. That became infructuous.
Yeah.
When my learned friend called for the custody certificate,
Yeah.
he should have asked for the certificates of everybody. Let him bring it. This is how matters are delayed.
So,
The
the
state is the prime responsible for.
IA number 84 of 25, this is an application for bail. The Learning Council for the state submits that he has only obtained the custody certificate of appellant number 1, S. Balaji Acharya. However, he may be given some more time in the custody certificate in respect of the Bontorek, pardon. Appellants number 2 to 6, है ना? Put up this matter. Put a सप्ताह पर रखा. 1st September पर्यंत. Yes. Learning Council for the informant is present here. Next.
Item 13.
Okay, Arjun. Next.
Item 14.
The appellant is in custody since his arrest matter, that is 19th of October 2014.
Have you obtained that custody certificate? And you were asked to supply the deposition copies? You have supplied. No, not to us, but to the State Council.
Both.
Sure.
Certified to the honorable court.
Mr. Naik,
My lord.
he said that he's in custody since 2000.
19th October 2014, madam.
No, that what is the name?
Partha Karu.
But the trial court judgment reports otherwise. You come to the accused details, you will find that the last column, page number 2.
Yes,
second page re. Last column re लिखा है जी 19/2014 ରୁ 25/7/2017 तापर बोधे आपण बेल पड़ी जाइछंती तापर पुणी 6/3/2024 ରୁ wrong. Now you have been also found guilty under 360 Act.
My lord.
The notice, what about the notice?
No, it is first time.
The notice has to be served on 360 Act. Extra copy of the appeal memo along with the interim application be served on the Learning Council for the state, since one of the offense under which the petitioner has been found guilty is under section 3(2)(b) of the SC/ST POA Act. Be served on the Learning, which will be sent to the inspector in charge of casing for its service on the informant in casing PS case number 107 of 2014. बाकी से जो फॉर्मेट रे कर देवे, ताकि इंटीमेशन देवे, यदि लीगल एड ये यदि ये करिए वकालत ना होते अच्छी से छोड़ा कर दे तो, है ना? हाँ, तो इस नोटिस को बाकी कस्टडी सर्टिफिकेट आनी में, है ना? आपरे अपन करो क्रिमिनल एंटीसीडेंट आउ कंडक्ट इन जेल, है ना? Yes, next. Yes, Mr. Mahanti.
Two appeals are there, Lordship.
Yeah.
Lordship, in the first appeal, the petitioner is in.
You have supplied the deposition copy.
Yes, Lordship, I have already supplied. I am having the receipt.
So you were on bail during trial, or?
Yes, Lordship, I was on bail.
Case of direct evidence or circumstantial evidence?
Lordship, last in theory is there, Lordship.
No, eyewitness screen hati.
Good eyewitness achieved, but he has turned hostile, Lordship.
Okay. So now what is that circumstance according to the?
Lordship, two appellants are there. In the FR, it has stated that.
Two appellants have filed two separate appeals?
Two separate, Lordship.
Okay.
Lordship, one made two. And in the second appeal, Chogla is there, Lordship. In the FR, it has been categorically stated that Mittu, Chogala, Millan, and two others came to the house of the appellant, and thereafter they asked him to accompany.
Came to the house of the appellant?
Came to the house of the victim, Lordship.
Deceased?
Deceased, Lordship.
What is the name of the deceased?
Bhakta Taruna Janna.
Just a minute. when the occurrence took place?
Lordship, in the year of 2013, Lordship. Lordship 3/12/2013.
Both of you were on bail or even
Yes, sir. Yes, Lordship.
on bail? Okay. So come to those circumstances which are discussed in the judgment.
Yes.
What are the circumstances the learning trial court has relied upon to convict you under 302? Are you ready or you will?
Yes, Lord. Starts from para 30, Lordship.
No, we just want to know from you. Don't look at the brief. Just tell us what are the circumstances which have been found by the learning trial court against you on the basis of which.
Because these two persons along with three others had.
So that is last scene is one.
Last scene is there, Lordship.
Then what else?
Subsequently, the informant, the wife of the deceased, received a telephonic conversation or telephonic call from PW12.
Oh.
Lordship, that Milan has fired gunshot at the deceased, Lordship. And subsequently, he was taken to the hospital.
Eyewitnesses turned hostile.
Yes, Lordship.
Another PW 10 also another eyewitness.
PW10.
But he was only witness to the kidnapping, Lordship.
Let us see that PW10. Which paragraph, Mr. Nayak?
Second para on 10/2/13 at 5 p.m. I was talking with the Deepak Bhoi and Rajkumar Bhoi at inner temple of our village, Shankarpur. At that time, 3 persons came by Hero Honda CBZ motorcycle and accused Nursimha Bhera was driving their motorcycle. Mittu Singh was the pillion rider. I do not know the other pillion rider. Milan Singh came by white color TVS Apache motorcycle and Devan Bhai was the pillion rider of the motorcycle. They went to the motorcycle towards Shankarpur. After half an hour, they came by the motorcycle and Milan Singh was driving TVS motorcycle. Bhaktadran Jana deceased was middle pillion rider, and after him, Dhunna Bhai was sitting on the motorcycle. Hero CBZ was driven by the Nursimha Bhera, Chogala and Mrityunjay Jana, the pillion rider, and the followers. They went by.
This is about the last scene.
Last.
No. He said that the eyewitness to the commission of murder.
That is the 13 what that.
He has been declared hostile. That is PW
30.
PW 13 hostile. So one is last scene. What else is there?
Apart from that, documents, Lordship.
So this last scene that was saw on 3/2/2013, when the dead body was recovered, and from which place?
Lordship, he was taken to the hospital, Lordship.
Para 30 of the impugned judgment sheet, these are the circumstances.
Yes, Lord.
Para 30.
30.
30 at page 60. With the prosecution is cited against you. 30.
Paragraph 30.
Lordship, in CLA number 490. CLA number 490.
Accused persons abducted the deceased. That is stated by that.
Age regard.
Yes, sir.
Yes.
And after 30 minutes of such abduction, Litu means who is the Litu?
Lordship, PW 13, Lordship. In 495 is PW 13, Lordship.
Telephoned the informant that her husband has been killed by gunshot. To कितना नंबर सकी?
Lordship, PW 13.
PW 13. How he came to know?
He was accompanying them, Lordship.
He has not supported the process.
He was accompanying them, Lordship, and he was also injured.
Okay. Let us see that PW 13's evidence. Oh, he was totally hostile. Okay. So if he has turned hostile, then this part goes, they जो information देला बा तार जो से निजे खंडिया खबर हेतला gunshot injury इटा गला तनु बाकी रहिला abduction.
Yes, sir.
Has not explained how the disease sustained. So how many, acha, the dead body was found where? In the hospital?
He was taken to the hospital. Lordship.
By whom?
Lordship, by PW only. With Mrutyunjay. Because he has already intimated.
Okay, but he has
Turned hostile.
Now, who has seen you along with the deceased?
PW?
10.
Lordship, 10 is there. Another witness has also seen. Lordship,
So
PW
then last scene is there.
Last scene is a 10.
Last scene is there.
And 13 is the witness, but
Jibon from Jena, they have all seen us taking the deceased.
And what about your custody date? You are
Lordship, Nursing, Chowgala alias Nursing,
you are
4 years, more than 4 years. He was arrested on 17/2/2013 and subsequently released on 31/8/2016. And subsequently after the judgment, that is from 18 to 2000.
But in the impugned judgment,
yes, Lordship.
It appears that this two in the first one
He
was only custody for 2 months and 22
months, 22 days, and subsequently after judgment he is in custody.
Judgment means judgment ke lagi judgment
18 to 2025.
25. And what about the other one? This
He is in custody since more than 4 years, Lordship.
last Lepon. CRLA number 493 of 25. IA number 1390 of 2025. State election of fine allowed. Tapare IN number 1391 of this is an application for bail. The Land Counsel for the petitioner submits that the petitioner was on bail during trial and he has never misutilized the liberty in any manner. Further submits that the sole eyewitness to the occurrence, that is PW13, has not supported the prosecution case, and therefore the case is now based on circumstantial evidence. And the only circumstance available against the petitioner is the last scene, which is deposed to by PW10. He further submits that in view of the available material on record, there are good chances of success in the appeal and balance of convenience is in favor of the petitioner. Therefore, the bail application may be favorably considered. Land Counsel for the state opposed the prayer for bail and faced the evidence of PW10 as well as PW5. Considering the submission of the Land Counsel for the respective parties, since the eyewitness has not supported the prosecution case, nature of circumstantial evidence available on record, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Bail allowed. Second term sterilization of fine same order for you, but it is stated that you are in the second case you are not on bail.
Yes, Lordship, I was there, Lordship.
Then how this?
Lordship, he was released on 17/2/2013 and subsequently released on bail on 31/8/2016.
So this Chogala Varkala 495.
495, Lordship.
So that means they were not released simultaneously.
No, Your Lordship. Lordship, this was the first appellant surrendered in the year of 2019.
जो second term जो लिखी हुए Chogala alias Nursinga Vera जो टाउजी CRL number 495 of 25. Rather लिखी हुए that he was in custody for more than 4 years.
4 years.
More than 4 years. है ना? And he was also on bail during the part of,
Interruption.
he was on bail. बाकी सब उन्होंने समान थे ना. So stay relation of fine मध्ये allow कर दो bail. Rest of the matter of today.